entered into an agreement which purports to bind the company. That's not good enough. Every party contracting is deemed to know the law. Every party contracting is deemed to know the law. They know the promoter has no right or authority in law. They know it's only the board. Unless the promoter has a specific power of attorney, which is of course a different circumstance completely. So the concept that once a promoter has made a representation or an agreement, the company is bound may apply to a very small company where the promoter is held to be the alter ego. But the moment it is a public limited company or a listed company and there are public shareholders, that umbilical cord is broken. It can't be imputed to the company. Apart from which the board now has requirements of independent directors, etc. There are a couple of other points that may arise. It fell from your lordships, I'm told, the impact of sections 91 and 92 of the Evidence Act. Because as far as signatories to a contract is concerned, it's very well settled that that intention has to be garnered from the contract itself. And if my lord kindly turn to my main note, the first submissions at para 67, page 17. I've just analyzed and summarized the law there. Para 67, it is well settled that the intention of the signatory must be decided primarily from the language of the contract itself.
Which page are you on?
Page 17 of the
Original
main submission.
Yes.
I've cited just the judgment in Bangalore Electricity Supply Company.
Yes.
Intention of parties must be understood from the language they have used, considered in the light of the surrounding circumstances and object of the contract. That's very well said. So as far as signatories go, when you're ascertaining mutual intention, one will look at the contract. You can really not look outside the contract or add a term to the contract.
Yes.
But as far as non-signatories are concerned, like they've not signed it. That may not be a repository of their intent. So it's only for non-signatories that all these factors then come into play. Now, why is this important? Because if in a given contract, the signatory's intent is garnered from the contract as limiting the arbitration to the signatory parties. For example, if the clause says between the executing parties, disputes between the executing parties, or between the parties, and parties is a defined term and is defined very clearly. It's then not possible to impute all these factors to impute an intention on the signatories. And the doctrine requires mutual intention of not only non-signatory but the signatories as well. Everyone has to have the same mutual intention. There has to be a consensus idea. So the means of ascertaining that is different. Signatories has to be ascertained from the contract. And 91, 92 would not be a bar where the intent of the non-signatories. But it would be a bar where the intent of the signatories. And which is a critical component of establishing mutual intention. Page 18, I've made one other point. It's just to put it in the perspective. My lords have, in decisions, very clearly, in para 70 of my note, laid down tests for even implying a term into a contract. So they're very rigorous tests. The official bystander test, the penta test in Nabapa, etc. Now, if that is the level to which a test is applied for implying a term, then surely implying consent of a non-signatory has to at least stand to some rigor. It can't be just brushed aside by saying he's in just because he's part of a group. Now then, my lord, I'm again not troubling my lord in the next section under direct relationship. I've given indication of judgments of other countries which have not accepted the single economic entity principle. So England has not accepted it, Bank of Tokyo Karun, Singapore has rejected it. And Singapore has rejected it on the grounds which I've set out in para 75. That One, it would be anathema to the logic of consensual basis of an agreement to arbitrate. B, ordering of companies within a broader group did not mean that one could dispense with separate legal entity. And C, if the doctrine was accepted, all one-ship companies would be considered as part of the same single economic entity, resulting in the liability of a one-ship company being visited on several or all of its other one-ship sister companies. Now, Singapore is one of the most forward-looking pro-arbitration jurisdictions, but it has not accepted this. England, of course, your lordships know, in Russell and Searle, wholly owned subsidiary was not held to be part of the arbitration agreement. Was held to be a party to the and Swiss law also, in para 77, the fact that one legal entity controls another is not sufficient to reverse the presumption that only the entity that Vodafone, then I've cited, I've shown that my lords are familiar with. Then para 79, a passage from Gary Bond, which is also instructive, and I'll just quote it from here. All of this is found in my convenience, I'll just quote it from him. Quote, Gary Bond provides that the group of companies doctrine provides that a non-signatory may be bound by an arbitration agreement where a group of affiliated companies exists and the parties have engaged in conduct such as negotiation or performance of the relevant contract or made statements indicating the intention assessed objectively in good faith that the non-signatory be bound and benefited by the agreement. It's not enough to have a group. And this is a very important factor which is often missed by tribunals heated in India. It's just not enough to just see a group. You have to satisfy further requirements of society. Then, my lord, I won't trouble my lords to read the commonality of subject matter and composite transaction. My lords, that's the principle of Olympus superstructure. You have a mother agreement, ancillary agreements. Chloro controls in para 73 has adopted that. But going to the next page, page 21, the participation, the predominant participation of the non-signatory is critical. So, Dow Chemicals we have seen. Para 85, Redfern and Hunter. Question is whether the non-signatory actively participated in the conclusion and execution of the contract containing the arbitration agreement. And your lordships have also, in Reckitt, Cheran and Canara Bank, considered these factors, such as negotiations, execution, performance, as key determinants of intent. Of course, every case will be on its own facts. I'm not for one moment suggesting that will not. And therefore, the involvement of the non-signatory in the negotiation of performance should be such that the non-signatory has actively assumed obligations of performance upon itself under the contract or chosen to be bound. Then one can say there is an implied acceptance under the contract, by contract. But a sentence here or a sentence there referring to the non-signatory can never satisfy the test of implied acceptance under the contract. And in Dalla's case, which I've earlier shown, but this passage I had not shown, but I'll just read it from here. Para 88, I've quoted. Dalla goes into this question. The UK Supreme Court says, 1, subjective intention based on objective evidence must show a conscious and deliberate act of involvement. And 2, additionally, if direct involvement in the negotiation and performance of the contract is by itself said to raise the presumption of a common intention that the non-signatory should be bound, it set an unworkable low threshold which would raise a presumption that many third persons were party to contracts deliberately structured so that they were not party. So, by merely saying involvement in negotiation and performance, in fact, you may defeat the whole intention of the contracting party, because it may be one thing when they enter into a contract. After a few years, one of the parties wants to make some claims, may suddenly decide to the contrary. But he must be bound to his election at the time of the execution of the contract. He consciously left out some companies. So all this has to be seen. And the test ultimately boils down to this. Are these factors or circumstances enough to impute an implied unconditional acceptance by the non-signatory of the arbitration clause? If they are not, then you can't draw in a non-signatory merely because it's part of a group of companies. And therefore, in para 92, for example, I've given some examples of the other way. So one would be mere incidental involvement in contract negotiation or contractual performance is insufficient. That's from Gary Bond. I've quoted from there. Then next in B, companies' awareness of a contract, including an arbitration clause between other parties, and its confirmation of one aspect of the underlying contract does not necessarily make the company a party to the arbitration clause. Let's take a case where a company A, which is part of a group, enters into a contract with company B. Company A takes on a variety of obligations under the contract. One of those obligations is stated in the contract that it will be performed by company C, which is part of the group. That doesn't make company C a party to the arbitration clause in the contract, because it can't be said that party C, by its conduct of doing one aspect of performance, has accepted that it is a party to this contract. Therefore, again, case by case. And a non-signatory without any causal connection with the process of negotiations cannot be made a party. These are not my ipse dixit. I've taken them from commentators. I've just gathered them together in one paragraph. And I've footnoted where the. No, I'm not troubling my lord with the next 2 pages, which is all the various theories. And in fact, when I read my learned friend submissions, there are many more. There's some 10, 12 theories. There are always theories. But each one has its own safeguards, qualifications, etc. Then we come to page 25. I've sought to answer the questions posed in Cox and Reeds. The first question A, whether the phrase claiming through or under in sections 8 and 11 could be interpreted to include the group of companies doctrine, and whether the group of companies doctrine should be read into section 8 of the Act, or whether it can exist in Indian jurisprudence independent of any statutory provisions. For the reasons set out in paras 50 to 58, persons claiming through or under in sections 8 and 45 cannot include the group of companies doctrine. The phrase is restricted to derivative claims, and the cause of action must vest only in the signatory party. That I'd covered on the last occasion. Then question B, whether the group of companies doctrine should continue to be invoked on the basis of the principle of single economic reality. It is submitted that the doctrine should not continue to be invoked on the basis of principle of single economic reality alone, for the reasons set out below. First, multiple jurisdictions have rejected the concept of single economic entity on the ground it vitiates the most fundamental principles of company law. In India, piercing the corporate veil, as stated above, is subject to satisfying certain stringent conditions. Second, the group of companies doctrine, being a consensual theory, is premised on the existence of a dispute arising from a defined legal relationship and mutual intention of parties. Sans intent, the application of group of companies cannot be invoked. Third, the jurisprudence around group of companies has entirely ignored the concept and definition of a group, and will not have referred to the accounting standards, where the group is defined as a parent with all its subsidiaries, and subsidiaries in turn is defined as an entity, including an unincorporated entity such as a partnership that is controlled by a parent. Control refers to the power to govern the financial and operating policies of an entity so as to obtain benefits. So it's not merely shareholding, it's to show actual control. I've also referred to the RBI master directions on this. And then para 103. Given the broad definition of group companies and control in modern day complex company structures, a network of multiple entities across jurisdictions, one common ultimate parent or common parent thrown at the top, may all be categorized as group companies, despite the fact that they have their own independent management and operations. The concept of a single economic entity may be viable in case of small family group structures, but would not stand water when looking at large group structures and transnational corporate groups. It is therefore not in line with today's economic reality. Otherwise, corporate structures that are common would automatically result in numerous companies being joined to arbitrations concerning just one or a few of the group. And this would render arbitration completely inefficient and unwieldy and undermine the independence of the legal entities and their party autonomy. Then 105 I've already dealt with in detail about the promoters. I'm not repeating it, Milord. At 107, my lord, I have referred to the test of tight group structure in the MTNL case. Again, saying that can't be the sole basis. That may be one of several factors, but that really can't be the sole basis for imputing the group of companies doctrine. Then page 27, question C. Whether the group of companies doctrine should be construed as a means of interpreting the implied consent or intent to arbitrate between the parties. Whether the principles of alter ego and of piercing the corporate veil will alone justify pressing the group of companies doctrine into operation even in the absence. Ranging from one of the first expositions in Dow Chemicals to chlorocontrols and Cheran, throughout the literature enunciated by Russell, Bond, Redfern Hunter, Hanushu, across the law propounded in various developed jurisdictions globally, the key theme that runs through a group of companies is mutual intention. My lords have seen that. Therefore, group of companies must continue to require this key element. It can't be discarded. Implied consent or mutual intention, what I've referred to in para 109, that is of all signatories and non-signatories. In 110, it is, as my lords have held in Cheran, group of companies is distinct and independent of theories of alter ego and piercing of the corporate.
That's 112.
At page 28. Whether the group of companies doctrine is expounded by chlorocontrols and subsequent judgments is valid. Now here, I have suggested, my lord, that there must be cumulative conditions, including the condition added by my lord in ONGC is performance, involvement in negotiation and performance, which is not there in chlorocontrols. And mutual intention, again, my lord, I have said, language of the agreement is primary. A bit of a repetition, I don't want to, my lord, read this. Then, my lord, page 29, there is observation by Justice Suryakant that there's some contradiction in chlorocontrols because in one paragraph, it is referred to as a clear intention of parties to bind both signatory and non-signatory. The next paragraph says a non-signatory. This is at page 30 of my note. I've given the extracted one. A non-signatory would be subject to the arbitration without their prior consent. But this would be only in exceptional cases. And I would submit there's no real contradiction there. Because when prior consent is referred to in the context of non-signatories, it obviously means implied consent. It can't mean by signature or in writing. So therefore, I don't want to trouble my lord with the rest. I've given a short answer, but really my submission is this, and I end with that, my lord, that it is critical to limit the doctrine. If my lords are minded to at all include it under section 7, it must be limited to the parameters of section 7, which is a concluded contract valid under the contract. It can't be otherwise. Otherwise, it falls out of the whole scheme of our law, both under the Arbitration Act, the Contract Act. Section 28 of the contract. And which would require unconditional vocal acceptance to be determined even by contract. I'm sorry, I've taken a little more time than I thought.
Yes, my learned brother has a question.
Of course.
Could this also lead to opening up at the behest of a third party innovation?
It's a very good question. My lord is right. A third party who is not a signatory can say either that it is a party to this contract or that there is a separate contract which replaces this, which is innovation. All sorts of complications could arise.
So it can, according to you, provided it satisfies 7 and 13.
Then it would have to still satisfy the Contract Act test.
An open end.
It would really open up. My lord is absolutely correct. It would really take it far beyond what was intended.
Therefore, this definition of contract being a written contract has provided.
But there is one caveat I might add, my lord, to my answer.
To play.
There's one caveat that if it's a ratio, then even the arbitration clause is novated. Then he would have to prove that the novating contract has an arbitration agreement. So a full-fledged novatio may then, in fact, undermine the whole.
Thank you, Mr. Bhatta.
Thank you.
Now, who will be addressing after this? Mr. Rai will begin first.
Lord, I appear in the first matter for the respondents, is a section 11 being filed by Cox and Keynes against SAP India and my lord, SAP Germany. And my lord, I'll just quickly address my lord Justice Simha's last question, my lord. Because, and I won't take, my lord, your lordships through much of the facts of our cases because your lordships are deciding, my lord, the matter on principle. But some illustrations would always help, my lord, how these principles apply in the real world of commerce. And, my lord, in my case, in the lead case, my lord, Cox and Kings entered into a license agreement with only SAP India in 2010. And that license then, my lord, grants them whatever softwares they want to get as licensees. It has an arbitration clause. And since, my lord, it's a license, the arbitration clause is an ICC institution arbitration clause and says that the arbitrators, other than the chairman, shall be persons well versed in computer science or, my lord, technical aspects of the law. It's got a specific qualification for the arbitrators. Now, under that license, Cox and Kings licenses various softwares from time to time. A wholly separate agreement is entered into 2015, where they license one more software from SAP India and want the services of SAP India to install license. That services agreement is also only between SAP India and Cox and Kings. Specifically says it's an entire agreement. Has a very different arbitration clause. Now, the disputes are SAP India actually commencing an arbitration against Cox and Kings. Cox tries to resist that arbitration, saying that the agreement is null and void, the services agreement. Then Cox and Kings goes into insolvency. And 2 days after it goes into insolvency, it commences an arbitration under that very services agreement it said was null and void against SAP India and also now SAP Germany. And it says it is commencing it against SAP Germany because at some stage when the services agreement was completed, one official of SAP Germany wrote an email saying we'll try and address the problems. And Mr. Advani, that email, according to him, meant that SAP Germany has not taken over the contract. That's why I digest to start this because in substance what they're arguing is some type of performance, in this particular case, an email written by one official novates the contract in favor of SAP Germany. I hope I make myself clear.
Yes.
And the reach, my lord, as my lord just said, my lord, this is very, very open-ended. In the context of agreements that are subject matter of as entire agreement clauses. The clause says, my lord, it's an entire agreement. The agreement also, my lord, your lordship, 16 times without number, says it can be amended only in writing agreed to between the parties. I'll show those kind of illustrative agreement clauses. Because, my lord, fundamentally what is being argued, my lord, is that the agreement is now being amended or an implied term is being read in. And my respectful submission, my lord, as my senior friend, Mr. Sambhata, just briefly raised, the test for reading an implied term is a very, very high test. I'll come to that, my lord, from Nabha Power. The word business efficacy, my lord, Chief Justice has used in some. That is, my lord, when your lordship finds an arbitration agreement and then wants to give it business efficacy. So, my lord, in IS form, when your lordship use, your lordship says, parties can't defeat an arbitration agreement by just saying, and then taking it out of arbitration. But the context in which your lordships used business efficacy was, there is an arbitration agreement, and your lordships are trying to give effect to that arbitration agreement. Today, my lord, business efficacy is being used to say that parties which have not signed any agreement are somehow to be brought in, not by virtue of Section 7. I stand entirely with Section 7. You don't have to be a signatory. It can be incorporated by reference. But, my lord, the group company, as I understand it, goes much, much further than Section 7. it says that without following the procedures of Section 7, you can be a party to an arbitration agreement. How? By there being some commonality in the transaction. I'll come a lot to the details. But by there being some commonality in the transaction, agreements cannot be implemented one without the other. So, Milord, in many respects, Milord, almost like a party claiming through an under, I take a lot of Mr. Kambata's submissions. A lot of his submissions, Milord, I adopt. But according to me, Milord, as an arbitration practitioner, trying to, Milord, set sound arbitral practice, that leads to the conclusion that Section 7 must be applied. But the group company doctrine, Milord, may not be an appropriate doctrine to find parties to an arbitration agreement. But the way I propose to proceed is, there are, Milord, various issues at play here. Milord, where your lordships have already engaged with the issues, I would only state my point. But where, Milord, there is a different perspective I wish to bring, Milord, I'll bring that point. And I'll largely follow, Milord, my written submissions, even though, Milord, they have evolved through the course of your lordships hearing this matter. Milord, the way I propose to proceed is this. I want to take your lordships, Milord, only to Dow Chemicals initially and chlorocontrol, because that is the fount of this doctrine. And Milord, Dow Chemicals, I'll show your lordships, is applying French law, which specifically says there is no form of an arbitration agreement. And then I take your lordships to chlorocontrol to, Milord, examine whether chlorocontrol made certain persons party to the agreement by virtue of the phrase claiming through or under, or by incorporation of the agreement contained in the mother agreement to, Milord, ancillary agreements. I'll formulate that. But, Milord, after examining that, I will take this matter on a clean slate. Can, Milord, the doctrine find its place in our Arbitration Act in Section 7 in 2.1, or even in 8 or 45? And, Milord, my submission would be that to do so would violate, Milord, the Arbitration Act, the Contract Act, and also the Companies Act. But the same result or a similar result may be reached by applying Section 7, by applying the group company doctrine. And, Milord, one other aspect that has been touched upon, but not fully perhaps, is in these cases, Milord, are we talking about joinder of parties? Or are we talking about consolidation of persons? Or are we in fact saying that some persons are necessary and proper parties, and therefore, Milord, even though they are not parties to the arbitration agreement, we must find a way to bring them here. And, Milord, the submission is this, that there is no doubt, Milord, that we must give the Arbitration Act its full meaning. And we must, in fact, Milord, endeavor to reach an interpretation that makes India arbitration-friendly jurisdiction. Or more than that, Milord, a jurisdiction that supports commercial work, and including commercial dispute resolution. But, Milord, with all humility and with all due respect, Milord, I submit that the group company law may in fact do exactly this. Milord, I don't want to, Milord, in a bench before I am, Milord, I don't want to, Milord, make this a partisan case of arbitration. But, Milord, it is a good example. It is a good example of a company sitting in Germany, not signing any contract. An email is authored saying we understand there are problems in services contract between SAP India and Cox and Kings. It will be looked at. Now, Milord, kindly appreciate, and again, Milord, my little senior friend made these points, Milord. This official by email cannot be, Milord, binding SAP Germany. Kindly see, Milord, the reach of what the group company doctrine in that sense may be proposing. And there will be examples and examples, Milord. I confess that there are some hard examples, and there would be examples across the, Milord, range. There would be, in a sense, a use of the group company doctrine, there may be a misuse of the group company doctrine. But my lord, the doctrine as formulated may not be susceptible to this kind of use or if I may, my lord, misuse. Because my lord, performance is, when do we say, my lord, the company has performed the contract? In Dow Chemicals, my lord, the other entities of Dow Chemicals were actually distributing goods through that distributor, Saint-Gobain. It was that corporate entity that was actually doing the distribution. It wasn't some parent company's official who just stepped in. And the same test would apply, my lord, for negotiation. Often, my lord, in negotiation, you would, my lord, someone from the parent company may also come. But the ultimate test is, if that parent company was going to be bound by the contract or the arbitration agreement, I appreciate, my lord, those are two separate inquiries. Why would the parent company not sign that contract? Or sign, or by an exchange of letters, or by incorporation, incorporate that arbitration agreement? But kindly see again, how does a parent company contract out of this? But other than its subsidiary signs an agreement. That agreement is an entire agreement. That agreement says it can be amended only in writing between the parties. Now, in that context, Lord, how is the parent even to contract out? Because it is never contracted in, is my respectful submission. So, my Lord, I want to say, my Lord, although I am contesting the group company doctrine, it is actually because I am not in that pro-arbitration. Unless there is clarity on who the parties are. Of course, my Lord, Section 7 will come up for interpretation in cases before this Honorable Court and in other cases. But, my Lord, that Section 7 itself provides the clarity. Within that also there can be contest. But the group company adds a layer of, my Lord, uncertainty without, my Lord, in my respectful submission, any statutory basis. And, my Lord, the further submission I will make is that the Arbitration Act or the arbitration procedure should be agnostic to whom are the parties. It should not be, my Lord, that if I take my arbitration to the ICC institution, I get a different result as to who are the parties. Whereas if a party files a suit and a Section 8 is filed, a different result comes. Or under Section 11, a different result comes. And I would not submit that this interpretation, this application of the group company doctrines may in some cases lead to that kind of contradiction. Where, you know, if it's a SIAC arbitration, a different result would ensue, whereas if it emanates out of India or in a second, a different result may ensue. And, my Lord, all this is also very relevant in the context of, you know, the Law Commission report. And the Law Commission report recommending the amendment to the definition of party and that amendment not being taken into account. My Lord, you should be aware that in the same Law Commission report also recommended the amendment to the definition of an award to include the order of an emergency arbitrator. My Lord, the emergency arbitrator and its public, my Lord, nicely commented in his emergency award that was not implemented by the central government because that would be like gilding a lily. The arbitral award always involved in emergency. But look, this would not be such a thing. Given the definition of a party that does not include the words claiming through another. We have a definition of party that is different from the English article, which too does not accept the group company doctrine, despite, my Lord, that broader definition of party. Even there, my Lord, the group company doctrine is not accepted. My Lord, with that preface, my Lord, and just 2 or 3, my Lord, illustrations that this Lord should raise, my Lord, I think, a basic case where it comes up, but agreement between a principal employer and a contractor, and the contractor in turn, my Lord, subcontracts various aspects of his work. Now, both these agreements have separate arbitration clauses. In fact, my Lord, when we appear for a contractor, sometimes, my Lord, there is no defense to the principal employer because our subcontractors indeed delayed work. My Lord, it sometimes becomes a difficulty when you're appearing for, my Lord, a contractor sandwiched in that sense between a principal employer and a subcontractor, my lord. I'm sorry. But, my lord, in my respectful submission, those are two separate contracts with two separate arbitration clauses. And therefore, the arbitrations would have to be and so, my lord, the last aspect of my submissions will be, my lord, judgments which have followed. Because in my respectful submission, my lord, Amit Lalchand may have gone one step too far where there were not even group companies where it was brought in. And my lord, so too MTNL, where Canfina was not a party to the arbitration agreement. I'll briefly take you, your lordship, through that. But my lord, Cherin was correctly decided. Because Cherin was deciding a case of Section 35 and when a person would be bound by an arbitration agreement. And there, my lord, Cherin, and I'll show that, my lord, was a clear nominee of the person who had signed the agreement. Cherin, my lord, bought the shares as a nominee. And similarly, my lord, the decision in ONGC versus Discovery was, my lord, correctly decided for this reason, that ONGC was seeking to bring in a party on the basis of alter ego. Therefore, Mr. Lordship said that before you decide the Section 16 application of that party, you must hear ONGC's application for discovery of documents. So, my lord, in that sense, the result was my the correct result. He said, establish that the counterparty to my agreement the law of one other and seek to impede in this arbitration. So, the judgments that follow. No, with that broad preface, my lord, and only because I'm the first to be arguing, my lord, against the group company doctrine as it were, my lord. I have also, my lord, and I will make submissions how it narrow. But in the first respect, the approach I would, my lord, commend to your lordship is that the very text in the reading of sections, your lordships would, my lord, deal with who is a sort of fine the application. Well, just 2 or 3 words.
No. Now you really, because you are the first person who's saying that, well, don't apply the doctrine at all.
Yes.
So maybe we can come back at 2 o'clock.
But,
Tell us what is your estimate?
both of us.
So how much time would you like?
Both felt we need an hour and a half each, my lord, spill over into tomorrow.
So because you start at 2 o'clock, then at 3:30 you should be done today.
Yes.
And yes.
And your lordship give us time tomorrow. Otherwise, we had agreed, my lord, we would share time. If
And
your
then
lordship tomorrow.
but 3:30.
Yes.
Then you can start at 3:30, and then you can finish by about say 12 o'clock tomorrow.
I think that should be it. That will be fine.
That should. And then that wraps up. Nobody else on this side,
I
right?
think Mr. Ghosh wanted to make just additional submissions, if at all. Sanjoy Ghosh. And well, that's it on this side. And I don't think he's not here, but
Because we are rising. Because if Thursday is declared as a miscellaneous day for some reason, then tomorrow we'll have to wrap this up. And then we'll be able to wrap it up because the others then can give us a supplementary note or something.
501.1 you want to address.
Yes. Thank you. Thank you.
Check.
Yes, Mr. Bank.
Lord, I had said I would briefly just touch on Dow Chemicals, just to explain its context, and then directly come to the chloro control. Dow, your lordship has seen, my lord, the distribution agreement designated Dow France for the delivery of the products. So, my lord, one of the non-signatories, as it were, Dow France, was designated in the agreement itself as one of the persons who would distribute the products. And therefore, my lord, we don't know all the facts because this is, of course, a redacted version of the award. But Dow Chemicals, France, as that legal entity, was distributing products to Saint-Gobain, the distributor. Now, my lord, it would stand to reason that that would be done through some written agreement. From time to time, the rates at which the goods were sold, the terms on which the goods were sold would either relate back to the distribution agreement or would otherwise have some terms. It's not in that context that an intention is gleaned to adopt the arbitration agreement contained in that distribution agreement to Dow France. But I hope I make myself clear, my lord. This is, your lordship has not put examples of legal relationships which would be non-contractual. And there would be, my lord, even in the corporate world, there would be some. I can't rule it out. But, my lord, your lordship may appreciate, my lord, typically, in the corporate world, if a corporate entity is performing, it would be doing so on the basis of some writing. It would be acting under like a distribution agreement like this. Dow France would be distributing goods. Now, my lord, it's in that context that this arbitral tribunal found, my lord, that those non-signatories were also parties to an arbitration agreement. But, my lord, because the facts, the more relevant aspect perhaps of Dow Chemicals is that the tribunal records that they are applying French law. And that's very critical, my lord, because as I'll show, my lord, French law has no particular form for an arbitration agreement. And in that context, perhaps these tests of
It's really cool. Yes.
And my lord, because my lord, Dow Chemicals, ultimately your lordships have to interpret our arbitration act. But I only wanted to, my lord, endeavor to persuade your lordships that Dow Chemicals is applying a different legal regime, which specifically does not have the equivalent of Section 7 of our arbitration act. And perhaps in that case also, there probably was a distribution agreement and purchase orders or something akin to that under that distribution agreement. in addition to the non-signatory being specifically named as a party that would distribute the products under that distribution agreement. Look, and as I said, French law contains no particular form. Now, my lord, I come directly to chloro control only to identify what are the contours of the group company doctrine as laid down in chloro control and where they derived that doctrine from or where they found it in our arbitration agreement. Lord, if your lordship comes to my written submissions now, I'll largely go as per that, my lord.
Yes.
Does my lord's have it, my lord?
You want to refer to chloro control now?
No.
I'll refer, my lord, to parts of chloro control and also my notes.
Submissions.
Yes. My lord, if your lordship has
No,
first
see,
my
one thing
submission.
which the nodal council should have done was, in the earlier CBs, what they have done is that they have labeled the submissions A, B, C. So then it becomes easier for the council to say, okay, I'm on C2 or C3 or whatever. Otherwise, it becomes, one second, I'm just trying to locate your submission.
Respondent SAP, last one. Written submission.
In the morning of
Respondent SAP.
This part goes like these written submissions set out the positions of respond number
I'm
2.
grateful. Yes, that's our submission. I was placing chloro control. And my submission is that chloro control carefully read may actually be a case of consolidation of disputes.
Let's see how you formulated it.
Yes.
You can read through it.
Yes. May I, paragraph 3. of my written submissions. Does my Lord the Chief Justice have it?
Why don't we look at para 2 as well? You just take 2 minutes, sir. You have
Yes.
set out the facts. It just gives us the
Your Lordship has, my Lord.
Roman para 2.
Yes.
You're right. Para 3.
Yes.
You're right.
I'm
You're
sorry.
right. Para 3.
Heading para 2, Roman para 2, I'm sorry. And I'll just read it first and then explain my submission. In order to appreciate the group of companies doctrine has evolved in chloro control, it's important to set out certain facts of that case. The plaintiff in the suit, that is chloro controls, was undisputedly a party to the arbitration agreement. Several of the defendants were party to one or more agreements, and all the defendants consented to arbitration during the course of the hearing. Out of the 7 agreements executed between the parties, 3, including the parent agreement, contained an arbitration clause. And no party had commenced any other proceedings in respect of any of the ancillary agreements. So, the ancillary agreements had separate arbitration clauses, and no party had commenced arbitration under any of those. And all parties, all defendants consented to arbitration, even those who were not party to any agreement that contained an arbitration clause. On the basis of the above facts, the doctrine was evolved, relying on the term claiming through or under in Section 45 of the Arbitration Act. However, as the ancillary agreements were appended to or explicitly referred to in the parent agreement, this court also found that the dispute resolution clause of the parent agreement had been incorporated by reference as contemplated in Section 7(5) of the Arbitration Act into the ancillary agreements. This is, my Lord, extremely important because perhaps part of the reasoning of chloro was that relying on Section 7, the arbitration agreement contained in the joint venture agreement had been incorporated by reference into, my Lord, the subsidiary or subsidiary agreements, my Lord. But now I'll request your Lordship just to read 3 or 4 paragraphs of chloro control to see how this doctrine has been laid out as distinct from what parties to an arbitration agreement are or can be said to, my Lord. If your
Why
Lord,
don't we actually complete reading this part?
Yes.
Then we can go there so that
Very
this
well.
part is over, isn't it? That's better. So that your formulation is clear to us.
Very well.
To know where this way.
yes, ma'am.
Para 5.
In chloro controls, the court noted that normally arbitration takes place between the persons who have, from the outset, been parties to the arbitration agreement and the underlying substantive agreement. However, arbitration with a non-signatory to the arbitration agreement and the underlying contract is possible if the non-signatory claims to or under a signatory. The court thereafter provided illustrations of a party claiming through or under, such as assignment, succession, novation, and piercing the corporate veil. The illustrations do not include application of the group of companies doctrine. And your Lordship will kindly have, my Lord, footnote 1. The illustrations where a party is claiming through or under, my Lord, would often be defined as parties in the agreement itself. Your Lordships have seen, my Lord, when a party is defined, it sometimes includes their permitted assignees or successors. The submission therefore being made, my Lord, is that these categories of parties or of persons would actually be parties to the agreement also in most cases. My Lord, for example, an assignment. A permitted assignee by the definition contained in the agreement itself will be a party to the agreement. And it was even, my Lord, in the Cheryl Properties case. And similarly, my Lord, if a party succeeds to the rights of another party, my Lord, if there's a merger of 2 companies, the successor entity will be bound, not just by law, but by the contract itself. The contract would define party means X and its permitted assigns or successors. Similarly, my Lord, the test of novation. And finally, even piercing the corporate veil. Lord, if your Lordships are piercing a corporate veil, your Lordships are saying that although A has signed the contract, actually you can pierce the veil and go up to the parent of A. Similarly, submission is that these illustrations are, my Lord, of a different category than the group of companies doctrine. These would, my Lord, legitimately fall either as parties to the agreement or claiming through or under. But these do not include, my Lord, the group of companies doctrine. Then, my Lord, paragraph 6. In paragraph 71 of chloro control, this court recorded that though the scope of an arbitration agreement is limited to parties who entered into it and those claiming under or through them, the courts under English law have in some cases also applied the group of companies doctrine. Millard, I've put a footnote here also, Millard. I think it's common ground among all counsel, Millard, that this statement may not be entirely correct, that English law also does not recognize the group of companies doctrine. Therefore, according to Chloro Controls, the group of companies doctrine entails extending the reach of the arbitration agreement to persons other than signatories thereto and the persons claiming through or under them. While the illustrations set out in paragraph 70 of Chloro Controls would cover persons claiming through or under a party, the group of companies doctrine is something more. The court explained the doctrine as follows. An arbitration agreement entered into by a company, being one within a group of companies, can bind its non-signatory affiliates, sister or parent concerns, if the circumstances demonstrate that the mutual intention of all the parties was to bind the signatory and non-signatory affiliates. So, in the first instance, the test was laid out in paragraph 71 as one that has mutual intention. It was based not on intention. Thereafter, para 8, Chloro Control provides two alternative bases for invoking the doctrine. These are, the underlying transaction is with a group of companies and there is a clear intention to bind the signatories as well as the non-signatories. This is again without intent. The second broader formulation was, despite the non-signatory not having consented to being bound by the arbitration agreement, it is joined as a party to the arbitration if it has a direct relationship to the signatory party, there is direct commonality of subject matter, the agreement between parties is a composite transaction, that is, performance of the mother agreement is not possible without execution and performance of ancillary agreements, and such joinder would serve the ends of justice. It is not this second formulation that was perhaps extended in Amit Lalchand to even a non-group company situation. And in my respectful submission, the group of companies doctrine is a bit of a misnomer. Because if your lordship finds intent to arbitrate, then group company or not,
It's a contract.
a party would be bound.
It's a contract then, because once there's an intent,
Yes.
then the question is, how do you, what is the evidentiary test for finding the mutual intent?
Yes.
Then Mr. Kambata just argued in the morning that, well, it has to resolve itself into a contract.
Yes.
In terms of section 7 and 13.
And the fact
It can't be really just an intent dehorse any written contract between the parties or written pleadings or written correspondence in view of our section 7.
And in the context of group companies, that may be one indicia, that may be one indication. But ultimately, the test would still be, is there an arbitration agreement formed as contemplated in section 7? And that's what I'm saying, in some senses, the group company doctrine is broader than even the word suggests. I mean, it could bring in non-group companies also. So the fact that it's a group company is one indicia, but it need not be limited to group companies alone. If there is a document incorporated by reference, even a non-group company will.
Actually, even point number 2 can resolve itself into mutual intent, you see.
Yes.
For instance, if you say that, well, there's a direct relationship with the signatory party, direct commonality of the subject matter, the agreement between the parties is a composite transaction.
Yes.
The performance of the mother is not possible without the execution of the ancillary agreement. Possibly there are elements of intent here also, but then the court goes and says that such joinder would serve the ends of justice.
Yes.
It's almost like an Order 1, Rule 10.
And that's what I was saying. This is a problem arbitration law faces as to necessary and proper parties. That is really somewhat at the heart of this dispute, of this issue your lordships are also dealing with. But ultimately, there may be no easy solution when parties have expressly not entered into an arbitration. But I'll just develop that and section 8.3 of the Arbitration Act, which hasn't been dealt with in detail as yet. But your lordships are right, Lord. Order 1, Rule 10 would apply to civil court. But it may not apply, or in my respectful submission, it ought not to apply, Lord, to bring a party that is, and again, Lord, I'm prefacing all this by saying that would be, in a sense, not defeating the sanctity of arbitration agreements and arbitration law more generally, Lord, because it is founded on consent. And your lordships have not expected that once there is an arbitration agreement, your lordships will give full play to it. The courts will not intervene except to the limited extent provided in the Arbitration Act. In section 34, your lordships have laid down an extensive jurisprudence.
So the essence of arbitration is that parties will enter into an agreement.
Yes.
With regard to who
Yes.
they will resolve their disputes with through a private forum as opposed from a public forum.
Yes.
That's the essence of arbitration.
I'm very brief.
It's not just that I, as a contracting party, want a private law forum as opposed to a public forum in the form of a court, but I also define with whom I want to enter into that transaction for a resolution of disputes through a private forum as opposed to a public forum.
I'm deeply obliged, Lord.
So it's not just the choice of the means of dispute resolution, but the choice of the parties with whom I will have that form of dispute resolution. In a court, that is not so.
Yes.
Court, the distinction between court and arbitration arises only in terms of that a court is a public forum.
Public forum.
There's no choice, section 9 CPC.
Yes.
Or 226 or 30. There's no option. Once one party goes, other has to come and the court will exercise. In an arbitration, you are choosing the forum.
Yes.
That's the point of distinction.
Yes. And
You are choosing the forum, choosing the person with whom you will have the forum.
I could not have put it better, but that's the heart of my submission, that when your lordships find
Second part of
parties have,
rising,
I'm grateful. Yes.
whether you can go beyond the written parties or not.
Yes, my lord, and I'm submitting, my lord, and I hope to develop it. That exactly what, my lord, your lordships are putting to me, my lord. It's not just the choice of forum, but it is whom you will arbitrate with.
In a very about the kind of person they would like
Exactly.
the matter to
Yes.
be adjudicated.
Yes. Well, therefore, all aspects. First of all, who will I arbitrate with? And then who will my arbitrators be? As I said, my lord, in my two agreements, the first agreement, my lord, specifically says that the chairman shall be a solicitor and the other arbitrators shall have a background of training in computer law, computer science, or marketing of computer industry products. Now, can this be clubbed with another arbitration that has a more general arbitration clause? I'll come to that, my lord, because that will raise serious concerns with regard to how institutions conduct their arbitration. Lord, and I'll come to those rules, because at the heart, my lord, as I try to submit, is some issue of joinder.
So it's layered actually. Parties agree firstly that they will not go to court,
Yes.
but that they will go to an arbitration. Second, they will decide who will the adjudicator be in the private arbitral forum. What will be the qualifications for that arbitrator? You're not bound to select anybody. You can say, well, I'll have only a chartered accountant. I'll have only a structural engineer. I'll have only a whatever. You can define the person who's going to. So you have a choice of forum, the exclusion necessarily of the court. Second, the choice of the adjudicator in an arbitration. And third, that you will also be entitled to define who will you arbitrate with.
Yes. Yes.
That we will not agree to an arbitration beyond this set of parties.
Yes. And
For whatever reason.
yes. My lord, I'll come to it, but since your lordship is putting it to me, my lord, those persons you are going to arbitrate with have certain rights under the arbitration agreement to, for example, nominate arbitrators. To take a simple example. Now, when you're not in the group company doctrine, if parties are added, what happens to the rights of those parties? I hope I make myself clear, my lord. My lord, I'll show that through reading, my lord, the standard arbitration clause. Really, what is happening is an implied term is being read in, where in place of parties, the words are being added parties or certain group companies.
Mr. Rai, therefore, the point, really the compass is twofold. Either we jettison the doctrine completely, which is your broader point, or alternately, we so structure it so as to bring it within the comport of our Arbitration Act.
Yes.
If we have no choice but to jettison it, certainly. But considering the fact that, the doctrine has held a field and has worked itself out now for a decade, the other option is to sort of define the contours
Guardrails.
and guardrails, as Mr. Sambata said.
Yes. Lord, I'll endeavor to, Lord, even, Lord, to, as your lordship defines the guardrails, Lord, I'll make my submissions on 8 and 45 and 7 so that those guardrails can then be correctly laid down, Lord, as per my submissions also. But your lordships are right, Lord. If your lordships find that the group company doctrine has a place in Indian law or in the Indian Arbitration Act, then a reading of section 7 and 8 will at least lay down the correct parameters for that doctrine.
All right, let's complete reading this 9
Yes.
and 10 now.
Well, at paragraph 9, the court concluded that though not all parties to the list are signatories to the arbitration agreement, they would be covered under the expression claiming through or under, as their interests are not averse to the interests of the principal company, and they derive their basic interest and enforceability from the parent agreement, with the other agreements falling in line with the contents of the parent agreement. Your Lordship has dealt with this expression in Charon Properties, where we're not claiming through or under, or in that context claiming under, is you have to claim in the same identity as the person through whom you're claiming. Chloro control places it as if there is a joint venture agreement and the signatories are signatories to other agreements under the joint venture agreement, a distributor agreement or a trademark license agreement. They are claiming through and under. That may not be with respect to correct test. You have to be claiming through or under the party, not through or under some agreement. And this becomes important because these agreements are the result of complex negotiation, of course, have their own separate arbitration agreement. And these entities tomorrow could be outside the group company also. Tomorrow, my lord, these entities could be sold by the Severn Group or the Chloro Group. They are always not separate legal entities entitled to their own rights under their respective agreements.
Let's quickly now go on to point number 3. This
Yes.
is your attack on Chloro now.
Yes. But may I just go directly to point number 5 first and come back?
Point number 5.
Yes, that is at page 6. I'll just deal with Chloro, and now I'm dealing with whether this doctrine can be found in 8 or 45, and then I'll deal with whether it can be found in.
Actually, why don't you read you've done it properly, actually.
Yes.
No? Let's go back to your Roman 3.
Yes.
You've evolved it logically, actually.
Very good. But what I've tried to submit in Roman 3 broadly is,
Let's go read.
yes,
Let's read.
arbitration is based on consent and party autonomy. But Section 9 of the CPC provides that all civil suits shall be subject to the jurisdiction of courts, except where there is an express or implied bar. As held in Dhulabai versus Madhya Pradesh, jurisdiction of the civil courts is all-embracing, except to the extent it is excluded by an express provision of law or by a clear intendment arising from such law. An ouster of the jurisdiction of a civil court is not to be lightly inferred. I don't need to place that judgment. I've just extracted the relevant principle. Because this is the guiding principle which ousts. Yes. Section 5 of the Arbitration Act contains that bar to the jurisdiction of civil courts. It ousts the jurisdiction of civil courts in matters, Lordship may mark, governed by the Arbitration Act, except where the Arbitration Act so provides. Lord, the submission was, Lord, that Section 5 ousts the jurisdiction of civil courts in respect of matters governed by the Arbitration Act. Therefore, Lord, to say that there is no inhibition in the Arbitration Act to this doctrine may not be sufficient. It must actually be found in the Arbitration Act, because ultimately it ousts the jurisdiction of civil courts. And Lord, how does the Arbitration Act govern it? Is the parties' agreement to arbitrate.
The first sentence is important, para 13.
Yes, the parties' agreement to arbitrate as a condition to the ouster of jurisdiction of a civil court is therefore essential.
Which is section 28 of the
and section 28 of the Contract Act. Once the clear intention to arbitrate, as expressed in an arbitration agreement, has been identified, then arises the concept of party autonomy, which has been recognized as the cornerstone of arbitration by various decisions of this court. Given party autonomy, parties are free to choose the seat of an arbitration, the number of arbitrators, the procedure for appointment of arbitrators, the rules governing the arbitral procedure, the institution which will administer the arbitration, subject to the disputes being arbitrable under the law applicable. However, party autonomy is premised on the autonomy of a person to choose to arbitrate and with what my Lord the Chief Justice was putting to me. It is in order to ensure that the ouster of national courts is not lightly inferred in favor of a dispute resolution by a private forum, and to give primacy to consent and party autonomy, that the Arbitration Act prescribes the form an arbitration agreement must take. And my Lord, I have footnoted the decision in Charon Properties versus Kasturi, paragraph 24. That's my Lord, footnote 5 of my submission. I could read it, my Lord, if your Lordship wants. Your Lordship have not laid down exactly that principle. Then, para 15, where commercial entities and persons of business enter into dealings, they do so with the knowledge of the efficacy of the arbitral process. The commercial understanding between parties is reflected in terms of the agreement between them. The duty of the court is to impart to that commercial understanding a sense of business efficacy. And there, my lord, I rely on your lordship's decision in IS1. But again, my lord, it is premised on a determination that parties have chosen to arbitrate and with certain other parties. Now, my lord, I deal first with section 7 and then with 8 and 45. The group of companies doctrine cannot be read into or from section 7 of the Arbitration Act. Consent to arbitration must be expressed through an agreement in writing. In a departure from the ordinary rule applicable to contracts, section 7 requires that an arbitration agreement must be in writing. This written agreement between the parties must be to submit all or certain disputes which have arisen or may arise between the parties in respect of a defined legal relationship, whether contractual or not. Section 7.4 sets out that an arbitration agreement is in writing if it is contained in a document signed by the parties or in the form of exchange of letters or other means of telecommunication or electronic communication, which provide a record of the agreement, or in the form of an exchange of pleadings where the existence of an arbitration agreement is averred by one party and not disputed by another. So, Your Lordship had noted that it can happen even post the dispute starting by the exchange of pleadings. But Lord 7.4, in my respectful submission, would be not exhaustive of the kinds of arbitration agreement and what it means for an arbitration agreement to be in writing. I've tried to explain later, while it is true that courts adopt a pragmatic and not a technical approach while construing an arbitration clause, this is only to the extent of not insisting that the agreement be in a particular form and not allowing the agreement to be defeated due to errors in drafting, such as misnaming of the arbitral institution or use of a particular nomenclature. In such cases, the court seeks to give effect to the intention of the parties. And these are my lord decisions that I've cited, Pricol and Govind Rubber. However, when the intent itself is absent, in that it has not been expressed in writing, a court cannot infer intent to create an arbitration agreement. And similarly, an arbitration agreement cannot be created based on the implied consent of a party or by reading into the contract an implied term. Or, one learned friend on the other side said, an implied written agreement. That would be a contradiction in terms of my respectful submission. It would be apposite to refer to Section 9 of the Contract Act, which deals with implied promises and stipulates that insofar as such proposal or acceptance is made otherwise than in words, the promise is said to be implied. Considering that Section 7.3 of the Arbitration Act states that an arbitration agreement shall be in writing, the question of reading implied consent into an arbitration agreement to bind as non-signatory does not arise. So, that's why I submit, that implied consent, Section 7.5 certainly provides that an agreement can be incorporated by reference. But an implied consent may not fall within the requirements of Section 7, which define that an arbitration agreement should be in writing. But this takes us into an area that perhaps has not been covered earlier, because really what is happening if an implied consent is being read, then an implied term is also being read into the contract, into the arbitration agreement at least, for the first instance. Perhaps even in the substantive underlying contract, but certainly in the arbitration agreement. An implied term is being read that some other persons are bound by that arbitration agreement. And that's what I'm going to try to lay down the test in Nabha Power. In Nabha Power versus Punjab State Power Corporation, this Honorable Court has held that courts may imply a term into a contract only if all the following conditions are satisfied. It is reasonable and equitable. It is necessary to give business efficacy to the contract. It goes without saying, and it is capable of clear expression, and it must not contradict any express terms of the contract. But if I may just pause here for a minute and explain this point. Your Lordships have an arbitration agreement, a typical arbitration agreement, that says any dispute or difference arising under this contract between the parties hereto shall be settled in accordance with the following procedure. And typically it says party A will nominate, party B will nominate, and the two nominees will appoint a third person. Now, what is happening perhaps by reading in an implied consent is that arbitration agreement is being now subjected to an additional term, an implied term. And to do that, Lord, the test would be much higher than just business efficacy. It would be, Lord, these tests laid out, this Penta test in Naga Power, which is that an official bystander test, that anyone sitting in the negotiating room, if asked, is this non-signatory a party to the arbitration agreement, would say, but of course. Well, that is how the test has been first put down, Lord. That someone would say, but of course, there is no doubt about it, that a parent would also have agreed to be bound by the arbitration agreement. And Lord, I'm placing it a little high because your lordships are dealing with a range of situations which this doctrine will apply. But in the context of modern corporations, group companies, group structure, it is hard to conceive how an employee would be able to participate in a negotiation discussion and bind the company itself, absent it being a signatory to it. I place that because, again, Mr. Khambata has taken your lordships through the provisions of the Companies Act. Ultimately, a company will act through its board of directors. And a significant agreement would have to be authorized duly and signed. It would be very hard to imagine a situation where an employee would be binding his company without actually signing the contract. And that's why I've tried to give an example of a arbitration clause in footnote 13, which is an arbitration clause between parties, the end of the second line. It's between the parties in footnote 13. And what is happening is, parties are therefore being added. An implied term is being written that it's not just parties, but parties and certain group companies. The other aspect which involves a layer of complication is where a group company has signed a separate agreement with its own arbitration clause, then that arbitration clause is being negated and the arbitration clause in the mother agreement is being given effect to. There are two situations. One is where the group company has not signed any other agreement or arbitration agreement. That may be one class of situations. But the other class is where that particular group company has specifically entered into an agreement with its own arbitration clause, as was there in fluoro control. Now, that arbitration clause is in effect being given a go-by. In effect, that arbitration clause is being given entirely a go-by, and that party is being told that you have actually acceded to or agreed to the arbitration agreement contained in the mother agreement. So, one of the guardrails I would respectfully submit is that even when applying this group company law, where a group company has entered into a separate arbitration, that arbitration agreement, where it has entered into none, perhaps mutual intent could be read to be part of the other arbitration agreement. But when the intent is actually expressed in a written agreement, including a written arbitration agreement, as was the case in Tribunal, that may be difficult to circumvent. Well, I'll read on from paragraph 8. It is ex facie evident that given an arbitration agreement in writing, which addresses itself to disputes between the parties, this Penta test is incapable of satisfaction. In effect, under the guise of business efficacy, the arbitration agreement is sought to be rewritten, ignoring the clear terms of the written agreements, which are, especially in multi-party, multiple contract situations, the subject of long and hard negotiations. And again, I wish to draw a distinction between when your lordships have deployed the principle of business efficacy to give full effect to an arbitration agreement from this anterior stage, where your lordships are examining whether there is an arbitration agreement, and if so, among which parties.
No, Mr. Rai, we're talking about business efficacy. What about litigation efficacy? There is another contract, consolidation of the proceedings. That would also require us to apply the principle. I mean, may not be in this fashion.
Yes.
But otherwise also consolidation, if it's relating out of same kind of a, we have to efficacy of the litigation is also a factor we have to take.
I bow to that observation. There is a challenge. There is a problem. The institutional rules also deal with this problem. They provide for consolidation of disputes where arbitration agreements are consistent with each other. Where, my lord, for reasons best known to the parties, they have agreed that a technology license agreement will be governed by the laws of, let's say, Germany, with a seat in Germany. But the trademark license agreement will be governed by another body of laws administered by a different institution. But the institutional rules would not permit consolidation. And my respectful submission, my lord, is that Section 8 is not a provision for consolidation. My respectful submission. Neither is Section 11. And in doing consolidation under Section 8, my lord, we may be affecting the institution's ability to run its arbitration as per the arbitration agreement with the parties. My lord, I bow down entirely to what my lord Justice Roy is saying. There has to be, my lord, litigation efficiency. But that is also in large measure something to be determined by the parties when they are negotiating. They may provide for how a particular dispute will be resolved if it involves all the parties to the joint venture agreement and the other subsidiary agreements. But ultimately, my lord, the cornerstone of it may have to be, my lord, the parties' agreement itself. And if they have chosen a unwieldy or unwise, in a sense, process, that is, my lord, what they have chosen. My lord, your lordship put it well, my lord, that there may not be a soft solution to hard negotiations. Ultimately, these are hard negotiations. And, my lord, oftentimes, I may say this, my lord, with experience as being a corporate lawyer in my next years, there are reasons parties choose particular seats or particular institutions or particular applicable law. And my lord, in certain instances, perhaps the Lord may not be respecting that choice as firmly as it should, my lord. Paragraph 20. Further, it is a set principle of contractual interpretation that previous negotiations and declarations of subjectivity included from consideration while interpreting the terms of the contract. Section 90 of the Evidence Act states that where the terms of a contract be reduced to writing, no evidence shall be proof of the terms, except itself. In Rup Kumar versus Mohan Thedani, the Honorable Court recognized the written contract, liberation on the part of the contracting parties, and it is natural that they should be treated with careful consideration, and that wherever written instruments, either by the requirement or by the contract of the party, be the repository, any other evidence is excluded, be used as a substitute for such instruments or to contradict. When the terms of the contract are clear and ambiguous, only the express terms can be relied on. Therefore, where an arbitration agreement clearly sets out the parties thereto and the arbitral procedure agreed among them, no intention to bind persons other than the named parties can be read into the agreement. Similarly, where the underlying agreement contains an entire agreement clause or a clause providing that amendments to the agreement, if any, can only be made in writing, the arbitration clause cannot be interpreted in a manner so as to expand its reach to parties not named as parties to the arbitration agreement. And I've just footnoted at footnotes 17 and 18, just an illustration of what an entire agreement clause looks like, and my lord, what a clause with said applications of the agreement shall be made except in writing. And my respective submission is, my lord, to the extent, my lord, the group company doctrine as formulated in chloro control, my lord, and I'll come to a narrower or prescribed version of it, my lord. But to the extent this group company doctrine as laid down in chloro control, it, my lord, goes against perhaps the written agreement of the parties itself. But as Mr. Lord, one of the tests that he laid down was that it should apply in reverse also. If a party can assert that it is a claimant under the, then it also has to be a defendant. In that context, Lord, I submit that you are therefore telling an opposite party that not just the party contracted with, someone else can also lay a claim against you. And that, my lord, would be reading an implied term. But again, your lordship, with a myriad setting, there may be standard form of contract where this issue may not arise with its full force. But where, my lord, can be defining that only they will be subject matter of an arbitration. Then parties are in implied terms being added. My further submission was that if that term is added, it must be done on the principles of NABA. And again, we're speaking with all humility and some sense of responsibility, but it's hard in commercial contracts how that test can be, how it can not be contended. A parent sitting in the US tended to be bound by the other without even signing. After my submissions on Section 7, I now come to whether this can be a principle found in Section 8 or 45 of the Arbitration Act. Before addressing whether the group of companies doctrine can be drawn from Section 8 or Section 45, the scope or nature of the principle. Sections 8 and 45 are provisions in aid of arbitration. Right, how a judicial authority must act when an action is brought before it, that is the subject matter of an arbitration agreement. The provision is intended to ensure that if an action is brought on a matter that is the subject of a party or any person claiming through or under the party can parties to be referred for arbitration. This legislative intent is also clear from of Section 40 and 41 of the Arbitration Act, with the words. But Section 8 and 45 are not which contemplate or can be read to contemplate the addition of persons as being persons found by the arbitration agreement. This is my respectful submission. These provisions do not purport to and cannot be relied on to alter the definition of an arbitration agreement as set out in Section 7. That the constitution of an arbitral tribunal or the parties to the dispute are matters separate from Section 8 is made clear on a reading of Section 3. 8.3 makes clear that notwithstanding the pendency of an application under 8.1, an arbitration may be commenced or continued, and even an arbitral award made. But may I request your lordships to just read that one provision with me? This has not been placed. Lordships has under Section 8.3. Section 8.1, which is the application. Notwithstanding that an application has been made under subsection 1 and that the issue is pending, an arbitration may be commenced or continued, and an arbitration may be made. Now, consider a control kind of situation where without one party under an agreement to which it is a party and that agreement has an arbitration clause. If it commences an arbitration under that agreement, before, for example, the ICC, it was the case in one of the agreements, then that arbitration would continue in just those parties. I hope I make myself clear. Because it is, again, I will endeavor to see how one can resolve the complex situation. But this is one complexity of the other nature that arises. The party which has a specific arbitration agreement is being denied the full effect of that arbitration agreement. And this is all done after negotiations between the parties. And this is I'm making a submission based on 8.3. Based on 8.3, that a party can commence its separate arbitration. And I'm partly responding to my Lord Justice Roy's comment that therefore 8 is not a provision for consolidation. So ultimately, consolidation has to flow from consent of the parties or the institutional rules deal. If their agreements are compatible with each other, the institutional rules will not provide for consolidation. But if you have neither consent of parties or compatibility of arbitration agreements, then there may be a certain and litigation inefficiency or dispute resolution. Separate from, I'm now on Roman 6 of my submissions. Separate from an understanding of the scope of Section 8, that it cannot and ought
It's
not
more or
be-
less the same.
Yeah.
5 and 6 are more or less the same.
Yes. But 5 and 6, Milord, 6, I was trying to explain, Milord, that test of claiming through and under. Let us read that. As stated in section 2 of these submissions, the court in chloro controls relied on the words claiming through or under appearing in section 45, subsequently also inserted in section 8, to conclude that section 45 contemplates reference of non-signatories to arbitration. As stated above, the court in chloro controls recognize the category of persons who would be persons claiming through or under. These are persons who claim in the same capacity as the parties under or through which they claim, such as assignee or successor in interest. As held in Sharon Properties, the expression claiming through and under directs attention to the source of the right and is a legislative recognition of the doctrine that an arbitral award binds every person whose capacity or position is derived from and is the same as the party in the proceedings. Milord, there's a similar reasoning, Milord, in 20, which is the Australian. Sir. But your lordships in paragraph 20, Sharon, Milord, laid out what it is mean to mean acting through or under. The cause of action of such persons is derived from a party to the other. They do not claim an independent right based on the implied consent to the contract. However, in chloro controls, the persons sought to be brought within the ambit of arbitration were separate corporate persons who claimed independent rights under separate agreements. These persons were not claiming through or under the party, but rather claiming independently in their own right. Therefore, the doctrine of group of companies as articulated in chloro controls cannot be traced from the phrase claiming through or under. At the highest, it may be contended that parties to an ancillary agreement have incorporated by reference the arbitration agreement contained in the parent agreement on the basis that the parent agreement references the ancillary agreement or annexes a form of that ancillary agreement to the parent agreement. This is also part of the reasoning in chloro. However, the arbitration agreement contained in the parent agreement can be incorporated into the ancillary agreement only to the extent that the ancillary agreement does not itself contain a separate arbitration agreement. Therefore, to the extent this was done in chloro controls, despite a separate, distinct, and different dispute resolution clause in a particular ancillary agreement, I just want to respectfully submit that even that aspect of the decision is required to be. Well, therefore, these are my submissions, first on section 7, then on section 5. But I'll rush through this next section, which is not that in earlier decisions, your lordships have articulated what it means to have an arbitration. And it's my respectful submission that that hasn't dealt with those decisions fully. Paragraph 13. We submitted that chloro controls is required to be overruled also because it did not adequately consider or contend with the previous decisions of this court on the subject. But in Wellington Associates versus Kirit Mehta, the court held that Section 7 of the Arbitration Act required the agreement must necessarily or mandatorily require the appointment of an arbitrator. Jagdish Chandra, Milord, I may just come to the italicized portion. The intention of the parties to enter into an arbitration agreement shall have to be gathered from the terms of the agreement. And that if the terms of the agreement clearly indicate an intention on the part of the parties to the agreement to refer their disputes to a private tribunal for adjudication and a willingness to be bound by the principle of such tribunal and such disputes, it is an arbitration agreement. But I'm placing emphasis on the fact that the lordship held that to enter into an arbitration agreement, that intention has to be gathered from the terms of the agreement, not implied. It has to be gathered from the terms of the agreement. And the court further held that while there is no specific form of an arbitration agreement, the words used should disclose a determination and obligation to go to arbitration and not merely contemplate the possibility of going for arbitration. Then, Your Lordship, Milord, paragraph 34 was Sukanya. The court, Milord, distinguished Sukanya on the basis that at that time, Section 8 did not provide for persons claiming through or under. But, Milord, at the end of paragraph 35, therefore, I make the submission in the last 5 lines. It underscores that the court in chloro control relied entirely on the language of Section 45 of the Arbitration Act to justify the group of companies doctrine without considering whether such input is consistent with the definition of an arbitration agreement in Section 7. Milord, there was a similar issue that arose in Indo-Wind. And this was not in that case. The court also did not refer to or consider the Indo-Wind entity was wherein an arbitration agreement entered into by two companies was sought to be extended to a third company. Indo-Wind, on the grounds that Subhuti was a promoter of Indo-Wind and that the person who had signed the agreement on behalf of Subhuti was also a director of Indo-Wind. The court objected these conditions, stating that if the director who signed on behalf of Subhuti was also a director of Indo-Wind, and if the intention of the parties that Indo-Wind should be bound by the agreement, nothing prevented Westcare insisting that Indo-Wind should be made a party to the agreement and requesting that the director who signed for Subhuti also to sign on behalf of Indo-Wind. This is in some senses the heart of the case, that there is nothing that prevents parties from insisting that that non-signatory sign the agreement at the relevant time. The court also dismissed the attempt to draw an inference that Indo-Wind party to the arbitration agreement of the conduct of the parties, holding that while an ordinary contract may be entered into oral or spelled out from correspondence, the same cannot be said. The court held that if Section 7 says that an arbitration agreement should be in writing, it will not be sufficient for the petitioner in an application under Section 11 to show that there existed an oral agreement or that Indo-Wind had transacted with Westcare or Westcare had performed certain acts with reference to Indo-Wind as proof of an arbitration agreement. And I just want to spend a little time on this aspect, on performance. Again, performance must be performance of a corporate entity as a corporate entity. It can't be without my submission that just by an employee writing a letter or an email saying that I understand that the services agreement with SAP India has some difficulties, we are working to iron out those difficulties. That contract then is taken over by SAP. But therefore, performance.
It said that we'll take care of the issue.
Yes.
Something to that effect.
Yes.
So when you say take care, what would it mean that the subsidiary in India is not able to take care and will take care? Well, of course, you have said that it may not be a letter written by the company itself, but one of the person on the company.
Yes.
But then the person to whom the promise was made or the assurance was given, they would go by that understanding that the principal has said that we'll take care of the issue.
Tax security lordships are not going into that fully. Of course, the email originated from Cox and Kings. What that correspondence can mean, in my respectful submission, at the highest, is that we will look into how SAP India is executing this contract. Kindly similar, by that email, SAP Germany is not going to start receiving consideration for the contract. The consideration that is flowing. Therefore, the entire performance is still by SAP India. Qua Cox and Kings. Cox and Kings has no relationship with SAP Germany. I dare say they have no contract.
That's right.
But they actually will not have no legal relationship, although that's a matter separate. That is a separate matter from the arbitration agreement. But what is being done in instances like that is really someone senior in the organization is saying that we will talk to our colleagues in SAP India and they will execute the contract. I hope I make myself clear.
No, we may not exactly go into the facts here.
Yes.
And precise correspondence. But suppose the correspondence is such an issue which is arising between A and B, and C, which is the German parent company, C says that we'll take care of it.
Yes. Again, that is an email authored by a particular employee.
No, let's not go into precise the facts.
I appreciate it. The submission that I leave it at that, we talking there of an assignment of the contract or even an ovation. And if that is what we are doing, then is that consistent with the terms of the contract itself? And it will not be consistent. That's when these issues would get a life of their own, in the sense that if this goes into an arbitration, your Lordship is aware we can't challenge the Section 16 dismissal. if Section 16 is filed before the arbitral tribunal and comes to be dismissed, then you have to participate in the arbitration through its entire journey. And you can challenge it in Section 34. And that's where, in some senses, the stakes are high to not involve a party that is not a party to the arbitration agreement. And juxtapose with how do modern corporations transact? They transact through written contracts.
No, that
The
threshold has to be very high.
Yes.
First and foremost.
US and Germany are providing services in India.
I mean, suppose the facts are such that yes, it could be understood as a novation of the contract. Believe or do
Well, the entire team working on it would still be SAP India. I'm only saying
no, that of course.
that may not be what the person also understands. It escalates the issue. But the person with whom we are is still always SAP India. We're escalating the issue. Someone will look into it, but the understanding may not be that simple that by just a letter, you making it to SAP Germany.
In golfing terms, if you use a rescue
Yes.
to get out of this tricky situation, the German company is saying, I'll rescue. What happens?
But I would only say about the German companies, the caddy who hands you the rescue.
Okay.
But you have to still hit the rescue club. And Milord, I'm only submitting this in the context of Milord, this issue will affect modern corporations. And Milord, if they were to make party to an arbitration agreement, which is a seat not chosen, procedure not chosen, that may have Milord some consequences, separate Milord from the fact of what this relation they have entered into with Fox and in this case. But if SAP Germany is faced with the situation, this case now not just that there's an arbitration agreement, but there is a contract or a claim against SAP Germany. And those are two separate issues, arbitration agreement and legal relationship. But the line is very clear. But ultimately, these parties that have made parties to the arbitration agreement to be made part of the main contract also. Ultimately, those are the claims that are being made. And I'm only respectfully submitting that would be done by a formal commission, in which case they would anyway be parties under the agreement, as well as paragraph 70 of the protocol. Where it is just a claim, it can't rise in my respectful submission to the threshold of innovation or an assignment of the contract. So I'll just place 38 because MR Engineers has a nice formulation of appropriate guardrails, perhaps. Para 38. Reference was made in chloro controls to Section 7.5 of the Arbitration Act and decisions of this court to incorporation by reference. However, the conditions subject to which a clause contained in one may be deemed to be incorporated in another. In MR Engineers versus Somdar Builders, the court held that Section 7.5 requires conscious acceptance of the clause contained in other document, and a general reference to the other document is not enough. The court also held that the court would have to examine whether the intention of the parties was to incorporate the entire agreement or only a specific portion thereof. The court summarized the principles relating to incorporation as follows. General reference to a document containing an arbitration clause is not enough. A clear reference to the document containing an arbitration clause is necessary. The reference should indicate intention to incorporate the arbitration clause. Where a contract provides that its execution or performance shall be in terms of another contract, which contract also contains a provision for settlement of disputes by arbitration, the terms of the referred contract relating to execution performance alone would apply, and not the arbitration agreement contained therein, unless there is a specific reference to the arbitration clause. This requirement may not apply where the contract provides the standard form of terms and conditions of an independent trade or professional institution binding the parties, and such standard terms containing arbitration clause. And 5, the arbitration clause sought to be incorporated should be capable of application to dispute sought to be incorporated. This decision further supports the conclusion of this court has always required the parties put a firm undertaking of agreement to arbitration, absent which an arbitration agreement will not be deferred. And then, my lord, chlorocontrol I've dealt with, my lord, para 158 use this expression of incorporated by reference. In the face of a contradictory dispute resolution clause, that, my lord, reference may not be missed. And finally, my lord, paragraph 41. The court to refer a non
Let's go with this. So how long now, Mr.
Lord, 15 or 20 minutes. I'm conscious of my time. Lord, I'll just rush through some of these points.
You address us more on seven. Seven
Yeah.
is a crucial part of it because
Yes.
everybody is focused on seven.
Yes, Lord, may I just go through this itself and I'll just complete in 15
Yes,
minutes.
yes.
Roman 8, my Lord, of my written submissions
Yeah, that's right.
makes the point about the Law Commission recommendation.
That's right.
Right.
And Lord, at paragraph 45, I also narrate which other provisions of the Arbitration Act from party, which would all be impacted by this particular. Lord, I've already made briefly my submissions on the 4 cases, my Lord, that are also concerned here, my Lord, which followed chloro control. I'll just, my Lord, place on Cheran properties, my Lord. If I may just read
Yes.
my discussion, my understanding of, my Lord, Cheran properties.
Yes.
In this case, the court was considering a share purchase agreement which recognized the right of KCP to sell or transfer his holding in SPIL. This is important, provided the proposed transferees accepted the terms and conditions mentioned in this agreement. Similarly, the agreement itself contemplated a proposed transferee accepting the terms and conditions of the agreement. And it is pursuant to this share purchase agreement that KCP addressed a letter acting as the authorized signatory of Cheran and making a clear and categoric reference to the share purchase agreement, and that's paragraph 32. In that context, and examining section 35 of the Arbitration Act, which makes an arbitral award final and binding on the parties and persons claiming under them respectively, this court rightly, Chairman, the nominee of case, bound by the award, even if it was not a part of it. The decision, insofar as it refers to and relies on chloro, does so to negate the submission of the appellate, that is Cheran, that the group of companies doctrine cannot be applied in this case. It is in that context, Lord, that the court was asked to go into the group company doctrine. However, what is applied after the discussion of paragraphs 23 to 28 by the court, they was the group of companies in the phrase claiming, because in this case, Cheran property could only claim its right to the shares through KCP, who had suffered an award. So this is not.
So we held that Cheran is really bound by the award which was rendered against KCP.
Yes.
Though Cheran was not a party to the arbitration proceeding.
And
Because Cheran had the KCP, KCP had assumed a right to transfer its shareholding, provided the transferee agreed to be bound by the same terms and conditions. And Cheran had expressly stated that it was bound.
yes, yes. That
And
letter
therefore,
on
it had
behalf-
assumed, because it had assumed those contractual obligations.
Yes.
Then the award also bound it. That's what we said.
Yes, I'm grateful. But I'm grateful. That's how I've understood that decision. And really, red herring of chloro control was raised, but actually it was a case of keeping under because it was a assigning of. But Amit Lachan has now adopted just the second part of that chloro control test. And merely because agreements are interlinked, parties have become bound by the arbitration agreement. And in this case, it was an unrelated party also. And therefore, I've submitted with respect that that decision may not be correct because Roberts extended it purely on the fact that there are interlinked contracts. And I just read from line 8 or 9 the issue that may arise. Line 9 or 10, this may best be illustrated with a simple example of a principal employer who engages a contractor pursuant to a principal agreement. That contractor in turn engages one or more subcontractors under one or more separate subcontract agreements. Assuming the agreements contain separate arbitration clause, the mere fact that both sets of agreements relate to the same commercial project cannot be the basis to conclude that the subcontractors have agreed to be bound by the arbitration agreement contained in the principal agreement. To do so would defeat the expressed intent of the parties to be bound by that particular arbitration agreement entered into among them. And in the case of arbitration agreements that contemplate institutional arbitration, this would also impact relevant institutional rules on consolidation of arbitration. It would also have the effect of converting what would otherwise be a purely domestic arbitration into an international commercial arbitration, which in turn would determine whether the ground of patent illegality would be available to the parties to challenge the award. The submission here is when parties are, as in my case, SAP India and Fox and Keynes, then it's not a domestic arbitration. Now, if you bring in a non-Indian party, to use the term then you convert the character of that arbitration also. And that's where I come from when I submit that agreement has to be read a little carefully. But MTNL, Canfina was not a party to the agreement to arbitrate, and therefore I submit that decision may not have been made required to be overruled. ONGC versus Discovery, Again, Lord, facts will be clear. In this case, ONGC had entered into a contract with Discovery Enterprises Private Limited, but brought an arbitral claim against EPL and a sister company, Jindal. ONGC also filed an application for discovery and information to make its case that there existed functional, financial, and economic unity between DEPL and JDIL. Without considering this application, the tribunal allowed JDIL for deletion. It was this section 16 set aside by the discovery application should have been decided first, especially as JDIL failed to produce. Tribunal's order was prior to this topic. But the tribunal didn't have the benefit of chloro control because it happened much later. Inasmuch as this was the basis for the decision of this documents produced by DEPL may have made out ONGC's alter ego. And since the case was remanded on the basis the tribunal did not have the benefit of this court's decision in chloro control, the decision may not require reconsideration. Well, just very quickly, chloro control erroneously states that English law supports the group of companies doctrine. There's no international consensus on the applicability and extent of the doctrine. But I've reproduced the definition of party from the English Arbitration Act. I've reproduced that definition, and your Lordship sees, my Lord, references in this part to a party to an arbitration agreement include any person claiming through or claiming under or through a party to the agreement. And despite this, my Lord, English law doesn't apply the group of companies doctrine. Importantly, my Lord, Singapore, since it's such a pro-arbitration, also, my Lord, rejects forced jointers. The words used in that judgment are that it's a drastic. Similarly, the United States. Para 50 and 51, my Lord, I've again just set out Dow Chemicals and explain that arbitral awards do not create a precedent, and also rendered under different laws that are not. Lord, paragraph 11 of my submissions, again, I won't spend too much time on, my Lord, but I'll just read out the heading. The submission of the group of companies can be discarded only if the Arbitration Act expressly prohibits it.
That was Dr. Singhvi's sir.
Just read that by saying, my Lord, that section 5 says, as governed by this. And therefore, my Lord, it must be found in section 7, 8, or 45. My Lord,
Go to para 12, I think. That's your wrap up.
Yes, para 12. Rejecting the group of company doctrine advances arbitral practice and provides clarity. The following principles emerge from the discussion in the preceding sections. Arbitration requires consent as to the party's intention to arbitrate. This consent is provided by requiring an arbitration agreement be in writing. The intention of the parties must be gathered from the words used in the contract, and where those words are unambiguous, their plain meaning ought to be given effect to. Where the parties have incorporated into the underlying contract an entire agreement clause, the parties' previous negotiations cannot be relied on to discern whether the parties had an intention to bind any third party to the arbitration agreement. Of course, where there is a principal agreement and ancillary agreements arising therefrom, the arbitration clause contained in the principal agreement may be incorporated by reference into the ancillary agreements, provided that the ancillary agreements do not contain any inconsistent dispute resolution clause. However, this does not require the invocation of the group companies doctrine. In such a case, reliance will be placed on section 7, 5, and the law laid down in MR Engineers. Under Indian company law, an agreement entered into by one of the companies in a group cannot be binding on the other members of the same group, as each company is a separate legal entity which has separate legal rights and liabilities. I rely on Vodafone. Mr. Kambata has already argued. Therefore, my conclusion, the group of companies doctrine is inconsistent with these principles, and with the principle of party autonomy is submitted to the doctrine, or from advancing arbitral practice, in fact, detracts from it. This is because it introduces a significant element of uncertainty and discretion in determining the persons bound by an arbitration clause. Consequences of this uncertainty are significant. If a person asserts that it is not a party to the arbitration agreement, that person will have first to have recourse to section 16, and if unsuccessful, will have to participate in the arbitration proceedings before challenging an award under section 4. If it is then determined that it had not impliedly consented to the arbitration agreement, the award would have to be set aside and parties relegated to civil court for adjudication of their disputes. There may be no easy answers in disputes that arise in the context of multiple parties or multiple agreements. That is why institutional rules also have separate rules for consolidation of disputes or jointer of parties. Ultimately, though, the answer ought only come from the terms of the arbitration agreements entered into between parties, if the parties have entered into distinct separate arbitration agreements, or as in the case of chloro control, dispute resolution clauses that contemplate adjudication by a civil court, or if there are persons who are not party to any arbitration agreement at all, there is no basis to consolidate all the disputes applying in group of companies doctrine. It's therefore respectfully submitted that the doctrine ought to be held, if not valid in Indian law. Well, let me just add one footnote. If your lordships consider the guardrails or prescribing or limiting the doctrine, my respectful submission would be that the second limb of chloro control, which says that when there is a commonality of the agreement, even absent this non-signatory consenting, principle can be employed. That part, my lord, may be too broad.
Right.
The first part of the chloro control test, my lord,
The mutual intent part.
mutual intent, my lord, can be read in only in those cases where the group company is itself named in the contract as a party and actually performs the contract as a corporate entity.
Right.
The Dow Chemical kind of situation. So, my lord,
Thank you so much, Mr.
I also appear in the matter that Dr. Singh here, but I also appear on the other side. And that's just one sentence on that. That arose from a deed of family settlement, which was between certain individuals of the Kirloskar family. Dr. Singh's client filed a suit arraying all the individuals and also various listed and unlisted companies of the Kirloskar group. So, in fact, my lord, they filed a suit recognizing perhaps that the group of companies doctrine would not capture this. They actually filed a suit. As it transpired, my lord, the companies whom I represent said, without prejudice to their argument that they are not parties to the family settlement, the contract, they are agreeable to go to arbitration. That is what, my lord, we gave in the Bombay High Court. So actually, my lord, that case doesn't really arise here because, in fact, they've taken opposite position.
That's wonderful.
Right, we'll wrap up at this stage and we'll take up now.
One last statement,
Yes.
Kirloskar, my lord. As I said, my lord, that issue is the issue that Mr. Kambata addressed, whether individuals can bind listed companies. It doesn't really arise in this case. I just want to place that.
We'll start tomorrow with Mr. Diwan. Liz, you want to also argue? All right. You are instructing Mr. All right. So now the only submission left on this side is Mr. Diwan. George, you want to argue?
Intervention on national committee on that.
Oh, you are appearing for the answer to our national committee. So you will guide us dispassionately. You be like a really and a Michael Scurry.
Yeah, just 10 to 15 minutes.
And Manoj, there's Mr. Sanjay Ghosh who says he'll take about 10 minutes. He was here in the afternoon.
No difficulty. Mr. George, you can give us whatever material you have,
Yeah.
You have filed that.
I'll-
All right. You have circulated because Uncitrol will have a lot lot of underlying material.
Yeah, I mean, just about
we
model
should be
law
happy
and
to see that.
relation with the New York Convention.
All right. So about half an hour for you tomorrow, say about 11:15, 11 o'clock to 11:30.
For me,
Yes.
Yes.
Now I think we have heard substantial arguments.
I had in fact anticipated about an hour and a half. Your lordships had told me that your lordships would give me.
Now I think we'll wrap it up early because we have a special bench. And we don't want to spill it over because next week we have another conference starting on.
Much of you can just indicate to us.
We have to close now.
I'll certainly will try because I kept on cutting my cloth based on what you said.
If you have a good night's rest, I'm sure you can
No, I
Consolidate
certainly, I
further.
certainly will. If your lordships thinks I mean, I certainly don't intend to repeat anything that.
If you are tired like we are when we start dictating judgments, it will be very long.
Correct. But, so there are a couple of other facets which, in fact,
If you're fresh, that's what my brother says, then it will be brief and.
no, I certainly will. I mean, I don't think your lordships have ever seen me.
So half an hour and then
Because I need-
George 15 minutes for you.
Because can I just, because I'm certain I won't be done in half an hour. There are certain aspects of the.
20 minutes?
If your lordship is cutting, there should be a little.
Ram and Shyam.
No, your lordships may give me at least an hour and a half.
At least now.
I'm so grateful.
Be difficult to argue one by one.
I agree.
Both at a time.
Malas, posterity will also get to know what foolish arguments we made, Malas.
Also good arguments. But nobody
And of course,
admits.
good argument.
Nobody admits.
But it's we will, of course, this will be a great record for the.
No, no, you
for-
will-
Yes, yes. No, I think it's a wonderful idea.
Truly a court of record.
Yes.
Because every word is recorded.
It should be. It should be.
Every word is recorded.
Court of record.
Malas, in fact, I can share something with you. When Malas practicing in New York, we have these EBT proceedings, that is examination before trial. And I'm talking about this, about the 70s. Malas, they would record everything that was said in the course of that examination, even then. So that we know, lawyers knew what was going to happen.
Gujarat has e-court, in the sessions division, sessions courts, where even our internal whisperings are also recorded.
That's very dangerous.
Do you agree?
That's hazardous, completely hazardous.
Now, the only thing is that if there are two or more voices at the same time,
Yes.
that causes a little bit of a problem. But they obviously have personnel who will clean up the errors by the evening. They suggested that during the course of the day, the council will get the link, so the council can look at it. By the evening, they would have cleaned up the entire transcript and given it to us. So
That's wonderful. That's wonderful. That's truly
In VC
Truly.
proceedings,
a milestone, I would say, Malas.
in VC proceedings, anybody wanted to interrupt would lift their finger. So much there is no crosstalk.
That's
So
right.
we can follow that so that it won't
Hopefully.
overlap with one another.
So, Malas, let me just give your lordships a broadside view, Malas, of what is in issue here. Then I'll go on to the matter in some detail. Malas, as your lordship knows, Malas,
pen drive last time ka. Yes,
what is in issue is whether
last time ka.
the legislative party, that's the central issue, whether the legislative party in the House acts independently of the political party. That's the central issue. Because I will, Malads, while I go through the facts before your lordships, indicate to your lordships that on the 21st of June, when the first meeting took place, and we called, the group led by Uddhav Thackeray called members of the legislative party who belonged to now the Eknath Shinde group to come and attend the meeting, which was not done, pursuant to which some actions were taken. The contention throughout has been that there is a split in the party. So the issue before your lordships is, can members of the legislature within the House or comprising of those members of the House by themselves say that there is a split in the party because they don't agree with the leadership? This in turn would require your lordships to look at the 10th schedule and in that context interpret the role of the party within the legislature. Because after all, members of the legislature of any particular party get elected on a symbol of the party. They are there because of the party. And if they are there because of the party, Malads, there is an umbilical cord link between them while they are sitting in the house and the party outside. Can that link be severed and say, we are an independent set of people, we can do what we like? That will require, Malads, the interpretation of the 10th schedule. It requires your lordships to analyze the role of the whip, how a whip gets appointed, how he happens to be a bridge between the legislative party and the political party. And that nothing happens in the House without the political party taking a decision. Nothing happens. Mullah, the bill is introduced by the Treasury benches, any bill.
So is it your contention, therefore, Mr. Sibal, therefore, that unless there is a split outside the House,
Yes.
within the political party,
Yes.
that split cannot find recognition within the legislative party within the House? That's your...
Absolutely. That's my contention.
It could
That's the law also, Mullah, and I'll demonstrate that to your lordship. That is the law. Well, what happens, Mullah, I'm giving your lordships an example, Mullah. A bill is introduced by the Treasury benches, a controversial bill, let's assume. Bill there in which there is no consensus. Mullah, what happens? The parliamentary party, a group of members of the legislature are invited by the parliamentary party to sit outside the House in a particular room and say, this is the bill that's being introduced. What should be our position? The party decides the position. And it's articulated in the House. The legislative party by itself, dehors the party, doesn't decide what we are going to do, what you are not going to do. When a whip is going to be issued, Mullah, it's issued outside the House, translated inside the House. Okay, on this, you're going to vote against the bill that has been introduced, or that you will vote in favor, or that you will abstain.
But when the 10th schedule speaks about, say, a merger, for instance, now, there are very few exceptions in the 10th schedule, and it speaks of a merger.
Yes.
Ultimately, the speaker has to decide whether there is a merger. The speaker will not go into whether there was a merger outside the House, because then the speaker will be taking over the function of the Election Commission of India.
That argument is entirely on a different plane, Mullah. So we are not dealing with it, and we'll interpret the paragraph 4 for your lordships also.
The speaker's remit cannot lie outside the House.
Mullah, there's a problem. Supposing, all right, then let's analyze that for a minute, Mullah, since your lordships have raised the issue. Mullah, supposing there are 10 members of the legislative party in the House. right? And the merger has to take place of the political party. They belong, say, to the Malads, to the Samajwadi Party, right, Malads? Now, even paragraph 4 says that there's a merger of the political party, not the merger of the legislative party.
Right.
Right? So therefore, Samajwadi Party has to merge.
But no, if we accept your argument, that would mean that unless the Election Commission of India decides on a merger outside the House, the Speaker cannot take a decision within the House within
No,
his
Election
constitutional
Commission did
remit on
not
whether
decide.
there is a merger or not. That can't be.
No, Election Commission did not decide this issue, Malas.
How else?
Because a resolution will be passed that we have merged. And that will be informed. The Election Commission, they don't have to take a decision. They'll be informed. Majority of the members of the party will decide. They'll be informed. Once merger takes place, these eight people may say, we don't want to merge. And paragraph 4 says they need not merge. But I'll come to that later. This is a very complex issue.
Actually,
Not so.
Let's have a broad now framework of the facts, because
I will, Malaj.
in fact, that was our basic problem there. Unless we have a clear perception on the
I'm going
facts,
to
it's
do
very difficult for us then to look at the law divorced from the facts.
I entirely agree. But just, Malaj, may I just, Your Lordship, what are the issues that are going to be? I just told Your Lordships two.
we have to necessarily reframe the issues, because the issues which are there, which are reframed.
Yeah, it's not reflective of Malaj what needs to be decided. I agree entirely. Malaj, the other issue is, and that's never come up before the court. And that issue is, can a governor swear in a member of a legislative party against whom a disqualification matter is pending before the House? That's the other issue. Never come up before. What then are the powers of the governor in matters in relation to disqualification? This is not a case of a pre-poll alliance. This is not a case of a post-poll alliance. This is not a case of one political party. It is a case of people who allege that they are the party because they are a majority in the legislature. Right, Malas? What then are the powers, or what should be the function of the governor in matters of this nature, and how he should conduct himself? Because he also knows, because the disqualification petition is pending, Malas. He also knows. And if the governor does, Malas, swear him in as a chief minister, Malas, he actually topples a democratically elected government and aids in doing that because they happen to be majority in the legislature. Well, that's one of the issues that Your Lordships may have to consider. Then the other issue to be considered is, can a court, constitutional court, without referring the matter to the Speaker in the facts and circumstances of this case, decide the matter on its own, given the fact that there are no disputed facts? We are not going to, Malas, place before Your Lordships any disputed fact. All are matters of record.
Your question is, can a constitutional court decide 10 schedule?
That's correct.
10 schedule.
Yes, that's correct. That's correct. That's correct. Because under the 10th schedule, it is the Speaker to decide, Malas. Correct, Malas? But if the proceedings, Malas, are imbued with illegality, and given the conduct of speakers in the past, what then should be the attitude of the court in a given matter? That's the other thing. And then, of course, lastly, Malas, how do you deal with an issue? And that, Malas, because the last question in the reference is the powers of the Election Commission. And Your Lordships, and that's the last question, which is the last issue Your Lordships will have to decide, that under paragraph 15 of the symbols order, when there is a split in the political party. It starts with that proposition. That two factions have arisen pursuant to a split in the political party. Then which faction should get the symbol?
Will that arise in this case?
I'm sorry?
Will that arise here?
Yes, that's a question. That's a question. What is the role of the Election Commission in matters under the... That's part of the reference.
So under paragraph 15 of the symbols order, when two factions emerge in pursuance of a split.
Yes.
So what is the sequitur? How would you end the sentence?
Well, then what is the role of the Election Commission in deciding that matter? Should it await the decision of the Constitutional Court? Should it go ahead? Your Lordships only, Malas, as your Lordships will remember, in September said no stay. But your Lordship did not say how he is going to decide it.
But that, Mr. Sibel, is your independent challenge to the order of the Election Commission.
That's a separate issue, Malas.
We can't really decide.
No, that's part of the reference, Malas. I'm going to argue. I'm going to argue, Malas.
Can we, how do we...
He's saying
constitutionally, the Election Commission cannot proceed. Malas, the split would have to happen on 21st of June. There was no whisper of a split on 21st of June.
Your contention that therefore the Election Commission itself cannot proceed until the Speaker has decided.
Correct. That's what your Lordship said. No stay, fine, Malas, no stay. We went before the Election Commission and said, you cannot decide this matter. The matter is pending in Supreme Court. He said, no, but Supreme Court said no stay. And you will find that tomorrow, Malas, when your Lordship sit at 3:30. But be that as it may, that's the last question that your Lordships, your Ladyship will have to look at. So these broadly, Malas, are the issues that you might be asked upon to decide, Malas, that you might wish to decide. Now, Malas, let's go to the list of dates, because unless you have the facts, Malas, it will be... Malas, this is now PDF page 108 of the written submissions. It is marked as capital A, and I have learnt how to use the iPad.
Mr. Sibel, just wondering if you could just look at the issues that were framed.
Ladyship, I can't hear you.
Look at the issues that were framed once so that we know the perspective in which you're arguing. The issues that were framed for reference to the Constitution.
I can read those.
Can we just to review?
Yeah, I think it's a good idea.
Call before we reference order. Further.
Yes, reference order. Your Lordships will have that. Order compilation, Malas. PDF page 28.
Order compilation.
Orders compilation, PDF page 28. And the questions start at page 30.
Is the order dated?
It is on order dated, Malas, 23rd of August, 2022.
Page 28.
Page 28, Malas, and the relevant part, the question starts at page 30 at the bottom.
Order compilation, right?
28.
PDF page 30, Malas.
28.
Your Ladyship has it? Justice Shah, Malas?
Yes.
May I, Malas? A, whether notice for removal of a speaker restricts him from continuing with disqualification proceedings under the 10th schedule of the Constitution as held by this court in Nabia. Malas, I've already argued that. So Lordships, Malas, have deferred your Lordship's judgment on that. So we'll skip that for the moment. B, whether a petition under Article 226 or 32 lies inviting a decision on a disqualification petition by the High Court or the Supreme Court, as the case may be? That's the question that I have already formulated in different, the language is somewhat different, but the intent is the same. Then C, can a court hold that a member is deemed to be disqualified by virtue of his or her actions absent a decision to the Speaker? Actually, B and C are together, Manoj. They are interlinked.
Per se cases.
Yes. The language is somewhat, let's D, Malaj, what is the status of proceedings in the House during the pendency of disqualification petitions against the members? Malaj, it really doesn't clarify what it means. What is the status of proceedings? What it means is that can members against whom there is a disqualification petition pending have a role to play in the House while it is pending? Otherwise, you can topple any government you want. Then E, Malaj, if the decision of a speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Now, Malaj, this question only arises if you allow proceedings to go on. If you don't decide on the disqualification before, then this question arises, because if at a later point in time, you consider them to be disqualified relating back to the date when their act led to a voluntary giving up membership of the party or violation of the whip, then, Malaj, what happens to the intervening proceedings? A government has been formed, actions have been taken, policy decisions have been made. Would it not be better, for the purposes of, I personally believe, democratic traditions, that you should await your hands till the disqualification is decided first, because this problem will not arise then. Then, Malaj, F, I think is very, very important. What is the impact of the removal of paragraph 3 in the 10th schedule? According to me, that's central to the entire issue. Because now you don't have a split. The issue of a split doesn't arise. Which is why, if you want to go to the election commission, there has to be a split in the party, not a split in the legislature. That is not on record. No such split. So this is central, and we'll interpret paragraph 4 also in that context. Then G, what is the scope of the power of the Speaker to determine the whip and the leader of the House legislative power? What is the interplay of the same with respect to the provisions of the 10th schedule? Well, it's actually, again, convoluted in its expression. In simple terms, it means that how is a whip appointed and how is a leader in the House appointed? Is there a role of a political party, or is it something that the legislative party decides? Can majority of the legislative party members decide, I'll change the whip tomorrow? Can't be. So what has happened in this case, and I'll come to the facts, Mullahs, that sitting outside the House, X number of people said, you are no longer the whip. And those are members of the legislature only. Mullahs, I can give your lordship's documents to the effect. What happens is, when a leader of the House is appointed, the letter that is given to the Speaker is that the party hereby decides that this person will lead the House for the party. It's not the members of the legislature don't decide these issues. Similarly, whip. Because the whip is the bridge between the government or the opposition, whichever party it is, and the House, members of the legislature. That's why your lordships will see that nowhere in the Constitution does the word political party referred to, except in the 10th schedule. Because in the Constitution, you're dealing with institutions. You're dealing with an institutional framework within which all political parties function. In the 10th schedule, you're dealing with framework within which a legislative party functions in the context of the political party, resulting in disqualification. Then, Malat's H. Are intra-party decisions amenable to judicial review? I don't think that question arises. There's no intra-party decision in the legislature. So your ladyship is right that we need to look at some of these questions. Then I, what is the extent of discretion and power of the governor to invite a person to form the government and whether the same is amenable to judicial review? Well, it's governor's actions are always amenable to judicial review. That's not an issue at all. Question is, what should a governor do in the context of disqualification petitions pending and which are yet to be adjudicated upon? As a governor, Malat, who he is a constitutional authority, he needs to protect the constitution and the laws. In this very state, a governor, Malat, in the early hours of the morning, gave an oath, to the oath of office, Malat, made somebody a chief minister, and by the early morning, Malat, on daylight, he had to resign. Governors, and I say this with respect to all the institution of the governor, that governors have, in my respectful submission, acted far beyond their constitutional responsibilities, as we have seen, as I have seen in the recent past. That may not be a proposition that the other side will accept, but I'm giving only my view of the matter. It is unfortunate that governments are actively involved in the politics of the country. Then, Malas, the last one. What is the scope and the powers of the Election Commission of India with respect to determination of a split within a party? That's where, Malas, the question of para 15 of the symbols order comes in. Let's kindly now come to the written submissions of the petitioner. And the list of dates is at page 108. PDF 108.
Submission.
That is A, right? A, petitioner written submission.
yes, A. PDF 108.
Written submissions of the petition.
Written submissions, no?
Yes,
You are referring to return.
yes, yes, yes.
Not additional returns officers. Not additional returns officers.
A, Manas, A. Page 108, PDF.
Mr. Sibal, what we could also do is that, of course, we've seen the broad points of reference, but ultimately we'll need to narrow down the reference to the issues which you want to focus on.
Yes.
And maybe if you could, during the course of the afternoon, share that with the other side. We can have their feedback so that we narrow it down to certain specific issues. Because many of the issues which have been framed in the reference order may not strictly arise.
Yeah, it's not necessary. I
So
said that
let's
already.
sort of structure that so that it lends some clarity to.
Well, let us do that in the evening. Well, that'd be much easier for us. Because
difficulty.
if your lordships will allow us, because I'll consult my colleagues.
Yes, absolutely.
We'll
Also,
give some
you can
agreed
sit down,
issues, Malad,
in the evening and give us some agreed issues which will arise.
because afternoon may not be the most appropriate.
Evening would be fine.
Yes, we will.
And also then we can have some idea about, the time schedule, how long would you take? So that then we can restrict them as well and to certain time.
Malad, this side, Malad, will take 3 days, Malad.
Mr. Sibal, how long would you take? About 3 hours or so today?
No, Malad, I'll take much more tomorrow too.
Mr. Sibal, we'll have to have structured arguments.
All right, it'll be structured, Malad. I'm not going to repeat myself at all. Your lordship knows I myself, Malad, reduced,
After Mr. Sibal, after you conclude, Dr. Singhvi will
Dr. Singhvi and then Mr. Kamath, my colleague, Mr.
So
Kamath.
why don't, maybe we could do this. We have about an hour and 15 minutes before lunch, and you get 2 hours after lunch today. That's about 3 hours and 15 minutes. So maybe if you could conclude today by 4 o'clock, then we can give Dr. Singhvi until lunch tomorrow.
Yes.
And then a little supplement to half an hour after lunch for Mr. Kamath.
Yes.
And then they can start tomorrow afternoon. We are breaking at 3:30 tomorrow. So they get about an hour and a half in the afternoon. And maybe on Thursday, they can conclude by maybe lunch. And then we give you...
we'll try that, Malad. We'll try that. No issue, Malad. We'll certainly try and speed it up. I just think, Malad, your lordships may have questions yourselves.
No, of course. If we find that, of course, there's a little change in the time schedule, we can certainly do
Then, Malad, your lordships will also have to decide on the Nabam reference at some stage, what your lordship wants to do, because that sort of opens up another...
So we'll look at the list of dates?
Yes, Malad. So on 1966, Shiv Sena, founded by Bala Saheb Thackeray, to espouse the ideology and legacy of whatever, and has been recognized as a state political party by the Election Commission. Bala Saheb Thackeray was the president, Shiv Sena Pramukh of the Shiv Sena from its very inception and continued in the role till his demise on 17th November 2012. After the demise of Bala Saheb Thackeray, Uddhav Thackeray was unanimously elected to be president, Shiv Sena Paksh Pramukh of the Shiv Sena political party, and has continued to hold the position. At present, Shri Uddhav Thackeray unequivocally continues to be the Paksh Pramukh of the Shiv Sena, president of Shiv Sena, which is the highest position, as provided in the constitution of Shiv Sena. Copy of the constitution is annexed. 85, in view of the repeated defections of elected MLAs, MPs, and with a view to curb horse trading of an elected representative, the constitution was amended to include the 10th schedule by virtue of the 52nd Amendment to the Constitution with the following statements and objects. The evil of political defections has been a matter of national concern. If it is not combated, it is likely to undermine the very foundation of our democracy and the principles which sustain it. With this object, an assurance was given in the address by the President to Parliament that the government intended to introduce in the current session of Parliament an anti-defection bill. This bill is meant for outlawing defection and fulfilling the above assurance. So nothing in the 10th schedule should be interpreted to give credence to a defection. Nothing in the 10th schedule should be interpreted to somehow legalize a defection. Give credibility to that process. Because the whole object of the act is is to ensure that there are no unprincipled defections. Well, if there is an elected government, the attempt of the court and of the institution of the governor should be to allow the elected government to function till such time as a person is either disqualified or not disqualified. Right? And if there is a disqualification petition, that should be allowed to be decided. Because if you don't allow that to happen and you pass an order like you did on the 27th of June, unfortunately, it's the judicial order that led to this. It is that judicial order that led to this. Had that not been passed, we wouldn't be here. And if the speaker had been allowed to decide, and they would have gone up in appeal if there was a decision against them, or somebody else would have gone up in appeal. Yes. So, 7th of April, the 10th schedule was amended by the 92nd Amendment, and paragraph 3 thereof, which permitted 1/3 members of the legislative party to split, was omitted. Split is no longer available as a defense against disqualification under the 10th schedule. Please mark that. The defenses available were only two. That I have 1/3 of the legislative party has split, pursuant to a split in the political party. It is not a split of the legislative party. Paragraph 3, and I'll read that, Your Lordships, it is a split in the political party, resulting in 1/3 of the members in the legislative party, which gives them a defense to say that they cannot be disqualified. Similarly with paragraph 4, it's a defense. If I am 2/3 and there's a merger of the party, it's a defense saying, now I am entitled to be that party. That is part of the new party. Either a new original party or part of the merged party. That's a defense. That's why I indicated to Your Lordships, now there's no question of majority, minority, 1/3, 2/3, not relevant. If there's a split. Because what? The purpose of the defection law is to ensure that there is no unprincipled defection. Then, my lords, 23rd of January, organizational elections of the Shiv Sena political party for term 2018 to 23 were held, wherein Uddhav Thackeray was elected as president. The results were duly communicated in the prescribed format to the Election Commission on 27th of February 2018. Well, the Election Commission, and that, Your Lordships, is not relevant here. Election Commission in its order says, I don't have your constitution. Therefore, I will not consider that you are about the organizational wing structure. I will not consider it at all. So I go only by what is the legislative majority, and the legislative majority is 38 people from Eknath Shinde group, therefore they get the symbol. Anyway, that's another matter. Then, my lords, October 2019 elections in the 14th Legislative Assembly of Maharashtra were held. The seat distribution in the said election inter se of political parties is following. Your Lordship knows this. You have seen it before. Then, my lords, November 2019, a post-poll alliance was formed between the Shiv Sena, the NCP, as well as the INC called Maha Vikas Agadi to form a stable government in the state of Maharashtra, with the president of Shiv Sena, Uddhav Thackeray, being sworn in as the chief minister. 23/11/2019, prior to the swearing in of Thackeray, the governor hastily sworn in Devendra Fadnavis early in the morning as the chief minister of Maharashtra. This honorable court in Shiv Sena versus Union of India directed an immediate floor test, and Devendra Fadnavis resigned before facing the floor of the House. This only indicates how governors, mullahs, have been conducting themselves. How can a governor have sworn in somebody as a chief minister without knowing that he has majority in early hours of the morning?
This order is on 23rd November?
Yes.
Supreme Court's order?
Yes. Oh, the order, I just... 2019, 10 SCC 809.
Tell me later.
Yes. Then this mentioned anyway. April, May 2020, governor has been at loggerheads with the MP. 25/11. Oh, 2511, Sunil Prabhu. Now, this is important. 2511, Sunil Prabhu is appointed as Chief Whip of the Shiv Sena Legislative Party with the blessings of Uddhav Thackeray, President of the Shiv Sena political party, and the same was duly notified to the Speaker of the Maharashtra Legislative Assembly. Well, that, Your Lordship may actually, if Your Lordship don't mind, look at that document. Or do you want to read the dates and then later?
Please read the entire dates.
All right. Then April, May 2020, the Honorable Governor has been at loggerheads with the MVA government and has almost created a political crisis. Governor was sitting on Shri Uddhav Thackre's recommendation for nomination to the Maharashtra Legislative Assembly, despite a period of 6 months as an unelected member was about to expire on 27/5/2020. Further, the governor had blocked holding of the speaker's election. No speaker's election took place. Well, he was not a member of, there was a seat for in the legislative council which had to be, he had to be elected from that seat. He wouldn't hold the election for almost 6 months. This tells you, how constitutional authorities are acting. First you swear in somebody, he resigns the next morning, or then you have this problem. The BJP has been attempting to create divisions within the Shiv Sena, 20th June 2020, in the recently conducted MLC election, wherein despite having the requisite number of MLAs on its side, the MVA alliance led by Shiv Sena lost a seat to the BJP. This was because of cross-voting within the MVA and particularly within the Shiv Sena at the behest of the BJP. I'm not going to rely on these facts, because this is disputed. So these facts I'm not going to rely on. It was widely reported in the media that Eknath Shinde, who was then the Cabinet Minister of Urban Development and Public Works, has, along with certain others delinquent MLAs of the Shiv Sena, gone into hiding in the BJP-ruled neighboring state of Gujarat. Then 21/6, these are the undisputed facts that now start. To contain and allay the apprehensions that were arising in the party post the MLC elections, an urgent meeting of the Shiv Sena Legislative Party was called on the 21st of June. Eknath Shinde, along with certain other delinquent MLAs, did not attend the above-mentioned meeting, dated 21st of June. The party resolved in the said meeting to remove Eknath Shinde from the position of the leader of the Shiv Sena Legislative Party and appoint Ajay Chaudhary instead. Now, this is interesting because this is a matter which Your Lordships has to constitutionally consider. So a faction, which is the legislative party, decides that I will change the whip. Constitutionally impermissible. Then, the decision, Eknath Shinde, along with certain other delinquent MLAs, did not attend the meeting. Party resolved in the said meeting to remove Eknath Shinde from the position of leader of Shiv Sena and appoint Shri Ajay Chaudhary instead. The decision to remove Eknath Shinde was communicated by Uddhav Thackeray to the Honorable Deputy Speaker. After due verification, the Deputy Speaker accepted the change of leadership of Shiv Sena in the House. The reason why this happened was, because, as Your Lordship knows, he had to be a member of the Legislative Council because there was no seat in the Assembly. So the then Chief Minister became a member of the Legislative Council. Therefore, in the meantime, somebody had to be appointed, as the leader of the House, because they were the treasury benches. So Eknath Shinde was the leader of the House. And he was removed from his position of leadership by decision of the party. And the Deputy Speaker was told about it and he accepted it. In the larger interest of the party, it was thought fit to call for another legislative party meeting to give one more opportunity to the MLAs who were absent in the meeting on 21st June to show their loyalty and support to the original political party. Hence, another meeting of the SSLP was called. Individual notices were issued to all the MLAs of the Shiv Sena, and it was made adequately clear that, quote, failure to participate in the meeting without providing valid and adequate reasons in writing, communicated in advance to the underside, will result in consequential action against you under the relevant provisions of the Constitution. So they were told. On 22nd of June, despite the importance of the meeting called on 22nd June, aimed at consolidating the SSLP's strength to contain any possible horse trading, several dissident MLAs did not attend the meeting. Instead, the delinquent MLAs sitting in BJP-ruled states sent communications rejecting the holding of the meeting as illegal, which itself shows that those MLAs had been working contrary to the diktats of the original political party. 22nd of June, Sunil Prabhu, in the capacity of Chief Whip, responded to the communication dated 22nd of June of the delinquent MLAs rejecting the reasons given for their absence from the SSLP meeting as an afterthought, frivolous, backdated, and proof of them acting contrary to the interests of the original political party. That's the notice that your lordships read. 21st of June, dated 21st of June, received on 22nd of June at 11:30 a.m., but dated 21st June. Eknath Shinde wrote to the Deputy Speaker communicating his appointment as leader. So now, the legislative party or a majority of the legislative party can decide who they're going to be the leader of the party in the House, of the party, sitting in Assam. On 22nd of June, simultaneously a purported notice for removal of Deputy Speaker Narhari Zirwal under Rule 11 of the Maharashtra Assembly Rules, read with 179, was received at the Legislature Secretariat, expressing no confidence in the Deputy Speaker. Notice was hand-delivered by an unknown courier and not by any MLA. It is also relevant to note that none of the purported signatories of the notice had personally delivered any such notice, nor it was sent through the registered email address of any of them. The Shiv Sena Legislative Party in its meeting took note of Shri Eknath Shinde and rebel MLAs and the fact that they had indulged in anti-party activities and were trying to destabilize the MBA government. In view of this, it was resolved that the Shiv Sena Legislative Party meeting at the then CM's residence, that necessary legal action shall be taken under the 10th schedule against the errant MLAs. Now, who is CM? CM is a member of the Legislative Council. He is also the Param Pramukh, Paksh Pramukh. So he is the political leader. He is the one who decides. On 23rd of June, Sir Sunil Prabhu filed disqualification petitions under Para 21A, seeking disqualification of Eknath Shinde and 15 other delinquent MLAs of Shiv Sena. 24th of June, it was widely published in the news reports that the rebel MLAs led by Eknath Shinde were acting in collusion with BJP, and their entire logistical arrangement in Guwahati was made by the BJP leaders. 24th of June, Secretary of Maharashtra Legislative Assembly received an email from an advocate named Vishal Acharya attaching notice for removal of the Speaker dated 21st of June. On the same day, the Secretary of the Assembly communicated the decision of the Deputy Speaker to the email of Vishal Acharya, refusing to take on record the communication dated 22nd of June until the genuineness and veracity of any such communication and its signatories was ascertained. 25th of June, one of the dissident MLAs, Deepak Kesarkar, in a live interview declared that the dissident MLAs had formed a new group and named it Shiv Sena Balasaheb, and had also announced that they will have a separate leader whip, office, and everything else, just like a party has. 25th of June, Honorable Speaker, after due verification, was pleased to issue notices to the delinquent MLAs under Rule 6 of the Maharashtra Legislative Assembly disqualification on ground of defection rules 86, read with the 10th schedule of the Constitution, asking the delinquent MLAs to file their replies by 5:30 on the 27th of June 2022. On 25th of June, the National Executive meeting of the Shiv Sena was held. The said meeting was attended by over 163 representatives of the National Executive, and the leadership of Uddhav Thackeray as the President of Shiv Sena was unanimously and equivocally accepted by the National Executive. 25th of June, Sunil Prabhu filed an additional affidavit in the disqualification proceedings inter alia, containing the media reports that showed the hobnobbing of the delinquent MLAs with BJP leaders. 25th of June, Sunil Prabhu filed disqualification petitions against 2 independent MLAs and 1 MLA belonging to the Prahar Jan Shakti Party. The petition against the independent MLAs were filed on the ground that they gave up their independent status by taking part in the resolution dated 21st of June, passed by the rebel MLAs and signing the said resolution on the letterhead of SSLP. Also, the ground taken against PJP MLA was that the said MLA voluntarily gave up membership of the original political party by taking part in the said resolution dated 21st June and by signing the same on the SSLP letterhead. 27 June, issuance of the notice of 25th June by the Honorable Deputy Speaker came to be challenged by the 16 MLAs, including Shri Eknath Shinde, who filed a writ petition under 32. The said court, the Honorable Court, by the interim order dated so-and-so, in writ petition so-and-so, was pleased to, in the interim, direct this. Thus, meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the legislative party to submit their written submissions up to today today 5:30 p.m. is extended till 12/7. Well, just kindly note the language here as an interim measure. They have not filed a reply till date. We are now in February 2023. They have not filed a reply. Now, Malaj, prior to this, prior to the passing of this judicial order, Malaj, all that happened was happening outside of Bombay, outside of Maharashtra, in a state in the northeast. And by whom? By these members of the Legislative Assembly, that's all. There was no party in sight. There was no meeting of any party. Nobody called for a meeting of the party. And these are undisputed facts, Malaj. These are not disputed facts. Can the 10th schedule countenance a situation where, because of whatever reasons, Malaj, we don't want to go into it, a majority or even a minority of MLAs are just, Malaj, let's forget the majority, Malaj. Supposing a minority, you don't sometimes need the majority to topple a government. You'd only need a minority. Supposing it's a minority, Malaj, and the minority outside the state of Maharashtra says, I have formed. I am the political party. And then a judicial order is passed, Malaj, on a disqualification petition. Then no. If a petition is filed, you can file your reply after 10-15 days, Malaj. In the meantime, the minority gets in touch, Malaj, with the other party, topples the government, a new chief minister is appointed. Can you ever imagine that the 10th schedule would allow that? Can it ever be countenanced, Malaj? This is harakiri. This is legislative harakiri. Political harakiri. And you can't interpret the 10th schedule, Malaj, in this particular fashion to allow an elected government to fall. That's why I said it is judicial orders of this court that resulted in this. Then, Malaj, 27th of June. As several other members of the SSLP had also openly indulged in anti-party activity. Now, can anybody say, Malaj, that this is not anti-party or this is not giving up membership of the party? One of you sitting there say that we are forming a new party called Shiv Sena Bala Sahab. And you are sitting in a state ruled by the opposite, ruled by a party, Malaj, which was in the opposition. First you go to Gujarat, then you go to Assam. There is no dispute on that. These actions per se amount to giving up membership of the party, apart from the fact that you don't attend the meeting on 21st, 22nd of June. So what is the speaker going to decide? What can he decide? Given these facts. Then 28th of June, Malaj, late in the evening, the leader of opposition in the state of Maharashtra, Devendra Fadnavis, went to meet the governor and requested him to hold a floor test after the stay. That's where the role of the governor comes in. On 28th of June, immediately after meeting Devendra Fadnavis and with utmost haste, the governor sent a communication dated 28th of June, though received in the early hours of 29th of June, to the then Chief Minister, directing him to face a floor test in the House on the very next day. 30th of June, it is relevant to note that the Honorable Governor did not even attempt to ascertain from the Chief Minister whether he enjoyed the majority of the House. On 28th of June, the Governor, by way of a separate communication dated 28th of June, which was received in the early hours, directed the latter to forthwith on 30th June to convene the Assembly and hold a floor test. 29th of June, Sunil Prabhu filed a writ petition before this Honorable Court seeking a stay. So, as we said, please stay the matter. Please don't allow this to happen. Of the directions of the floor test in view of the fact that the disqualification petition of 42 MLAs under the 10th schedule are pending. By order dated 29th of June, in writ petition so-and-so, this court was pleased to direct as follows. Having given a thoughtful consideration to the rival submissions, we do not find any ground to stay convening of the special session of the Maharashtra Assembly. How? Vidhan Sabha on 30th June, tomorrow at 11 a.m. and with the only agenda of a trust vote. So therefore, you give legitimacy to those against whom disqualification petitions are pending, and such legitimacy that they are able to topple the government by colluding with another party, which is in opposition in that very state. That's the effect of the judicial order. So first, stay the proceeding before the Deputy Speaker, then allow this collusion and get an elected government toppled. What used to be the misuse of 357 has now been substituted by the misuse of the 10th schedule. 356 was now misuse of the 10th schedule. And the proceeding of the trust vote to be convened on 30th of June shall be subject to the final outcome of the instant petition. That's another interesting thing, brothers. Proceeding of the trust vote shall be subject to the final outcome of the instant petition as well as the writ petitions referred to above. So therefore, brothers, every action of the governor resulting in a new government having been formed is subject to your lordship's decision in these petitions. So you cannot give it the color and clothe it with legality, because the judicial order itself says that it's subject to. So you cannot say now the trust vote has happened, now a chief minister has been installed, now a government is in place, now you can't do a thing about it. The special session of Maharashtra Vidhan Sabha shall be conducted in accordance with the directions that contained in the communication dated through 28th of June of the Governor of Maharashtra. Then 29 June, Chief Minister Uddhav Thackeray resigned. Because he knows the writing was on the wall, having given legitimacy to those who... Then 30th of June at around 3 p.m., Eknath Shinde and Devendra Fadnavis met the governor and staked claim to form the government. This is also anti-party activity. No evidence is required on this. Then 30th of June, the governor, without taking into account the fact that the membership of Eknath Shinde itself was in dispute, here again the question of the governor comes in, in dispute. In the imminent disqualification petition pending against him, swore Shri Eknath Shinde in as the Chief Minister and Devendra Fadnavis as the Deputy Chief Minister of Maharashtra. The Honorable Governor thereafter directed Eknath Shinde to prove his majority on the floor of the House. We knew that everybody knows that he would have the majority thus. You can fool the constitution, but not the arithmetic. Then the governor, without taking into account the fact that the members, and I've read that. Then 30th of June, due to their anti-party activities which unquestionably amounted to relinquishing membership of the Shiv Sena political party, Shri Shinde, Tanaji Sawant, Uday Samant, and Gulab Rao Patil were removed from their positions in the organizational setup of the party by the undisputed president of the Shiv Sena, Shri Uddhav. Well, let's just note here, no meeting of any political party took place at the instance of Eknath Shinde. And you will see that tomorrow in the petition before the Election Commission. That alleged meeting, which I'll show is bogus, happened to have taken place on 18th July, after all this was over. And the petition for getting the symbol was filed on the 19th July, on the very next day. Then, Malats, one second. Yeah, I'll take it. Then, Malats, 1st of July, 2022, Shiv Sena Secretary sent a letter to the Election Commission intimating the authority regarding the removal of Eknath Shinde from the positions of Shiv Sena and change in the organizational setup of Shiv Sena thereto. Also, by the separate letter, the Shiv Sena Secretary intimated the ECI regarding the removal of Tanaji Sawant and Uday Sawant from the organizational position of Shiv Sena. Similarly, the Shiv Sena Secretary sent another letter to the Election Commission of India intimating the authority regarding the removal of Gurab Lal Patil from the organizational position of Shiv Sena. On 1st of July, an application for directions, IA such and such, was filed by Sunil Prabhu in the present writ petition seeking an interim order suspending the delinquent MLAs against whom disqualification petitions have been filed till the final adjudication of the 10th scheduled proceedings. The said application was mentioned before this court for urgent interim listing, wherein this honorable court directed to list the application along with the writ petition on 11th of July. Then 2nd of July, the Principal Secretary, Maharashtra Legislative Assembly, circulated working order for conducting election to the office of Speaker on 3rd of July. The said agenda showed that the name of Rahul Narvekar was proposed by the BJP MLA and the name of Ranjan Prabhar Salvi was proposed by Shiv Sena. So this Rahul Narvekar was proposed by a BJP MLA because he happened to be a member of the BJP. Then 2nd of July, Sunil Prabhu, acting as Chief Whip, issued a whip. Now, till that day, Sunil Prabhu is still the whip. Acting as Chief Whip of SSLP, issued whip to the members of SSLP regarding the election of the Speaker, scheduled on 3rd of July. All the party members were asked to remain present in the assembly and vote for the Shiv Sena candidate, Rajan Salvi. Sunil Prabhu issued a further whip to the members of SSLP regarding confidence motion, scheduled on 4th of July. All the party members were asked to remain present in the assembly until the end of the session and vote against the confidence motion. Well, as your lordships must just keep one thing in mind. It's not their case that they merged with any party. It's their case that they belong to the Shiv Sena. So if they belong to the Shiv Sena, then how can they disobey the whip? And vote for a BJP candidate against the Shiv Sena member. There is no evidence required here, Maharaj. Then on 3rd of July, Ajay Chaudhary, acting as the leader of the SSLP, submitted a letter to the Deputy Speaker requesting him to conduct the election of the Speaker of the Legislative Assembly by division of votes. Ajay Chaudhary on the 3rd of July submitted a letter to the Deputy Speaker requesting that the votes cast by the members of the Legislative Assembly who have incurred disqualification should not be considered during the election of the Speaker. 3rd of July, the election for the office of the Speaker of Maharashtra Legislative Assembly was held. Rahul Narvekar, the candidate for the Bharatiya Janata Party, was unconstitutionally elected as the Speaker of the Maharashtra Legislative Assembly after getting a total of 164 votes. During the elections, it was recorded by the Deputy Speaker that 39 delinquent MLAs of Shiv Sena Legislative Party, led by Eknath Shinde, had voted against the party whip. Now, at this point in time, there is no other whip. Now you will see on the evening of the 3rd, after
how many votes did the rival candidate poll that day?
Sorry?
July. How many votes did the rival candidate poll on the 3rd of July? Speaker.
That's all. We are not Mullahs on majority minority. Yes, that's correct. I'm glad that my learned friend pointed it out, Mullahs. Correct.
But therefore, if these 39 are excluded from 164,
Mullahs,
will they still have 125?
I'm not Mullahs on that. I'm only saying that they voted against the whip, therefore they are deemed to be disqualified. That's all I'm saying, Mullahs. I'm not saying, Mullahs, whether he would have. Supposing, Mullahs, all of them are disqualified, because on that particular day they voted against the whip.
These 39.
All 39.
No, but therefore, if you exclude these 39
Yes.
from the 164,
Yes.
they're still down to, they still get 125, right?
That's right.
The fact
Your Lordship is right, Mullahs. At the moment, Mullahs, I am not challenging. At the moment, Mullahs.
Because this comes soon on the heels of the trust vote, which takes place on the 30th.
Yes.
So this is now an indicator within 3 days.
Trust vote happened on the 4th.
Because Mr. Sibal, you don't
happen on the 30th, Mullahs.
right. You don't ultimately you don't face the trust vote.
Yeah, I don't, Mullahs. So therefore, it is held on the 4th. And we challenge the trust vote also. We've challenged all decisions, the election of the speaker, trust vote, whatever. All that is challenged. Mullahs, the question is, at the moment, Mullahs, we are dealing very, very limited issue. One, should the courts have given time?
That's a separate issue because it's an order which is an interim order.
Yeah, it's an interim order. What was the result of that, Mullahs? These people were able to topple the government without the disqualification petitions having been decided. There was an elected government, Mullahs, which was in power. The 10th schedule was used for the purposes of toppling an elected government. And supposing tomorrow, Mullahs, your Lordship holds by these actions, which are uncontroverted, that they disqualify themselves on both counts, 2(1)A and 2(1)B. What will be the result? And if your Lordship holds otherwise, let's assume, against me, then this will be, Mullahs, you have given them a model to topple every elected government.
Mr. Sibal, are we not still down to, if you are really looking at the numbers here, are we not down to the situation where the speaker's election at least indicates that because 38 was sought to be disqualified, there were disqualification petitions against the 38. Now, if you exclude the 38 for a moment from the 164 who voted in favor of the resolution for the speaker, you still have a situation where that's in very close proximity to the date on which the trust vote was to be held on the 30th.
Yes.
Now, you resign, right, on the 30th.
Yes.
And therefore, is this not really clearly an indicator that even excluding these 39...
That's all right. The speaker could have been, Mullahs. Yes, I'm not disputing that, Mullahs. I'm not sure what the arithmetic is.
Manoj, what
Half 145 is the halfway mark, Mullahs.
Manoj, what my Lord the Chief Justice
You
asked.
deduct 34, you are below, Mullahs. I'm sorry. In fact, the arithmetic is the other way.
No, Manoj, 288 was the total.
Yeah, the number. Just give it.
We'll just give you the
strength of the assembly. The actual,
Just 1 second.
yes,
Total strength of the assembly.
288.
That was there from Mr. Sibal's chart, which we
Right.
saw.
Actual votes received by Mr. Narvekar were 164, which is over the 50% mark of 144.
Just 1 second. Just one second. Total
So
strength
the
of the
half
assembly.
mark would be 145.
Just about.
1 second.
Yes.
164.
So if 144 is the halfway mark, 145, 164 votes were received by Mr. Narvekar if the strength was taken to be 288. If 39 MLAs are excluded from the strength of the Legislative Assembly, the effective strength comes down to 249.
249.
And out of those,
Just 1 second.
249, half of it is
249 and then.
and the effective votes received by Mr. Narvekar were 125, which is over 50% of the votes required. So under any circumstance, even if 39 MLAs are removed,
Plus, there were only 16 disqualifications.
yes, plus on